I'm hope I'm audible. Hello.
Yes, you are.
Yes, thank you, ma'am, and I'm extremely sorry for the blunder that I made. Uh, but we'll be moving ahead with the presentations now. We have our first presenter, Nandini Sahasane. Do we have her over here?
Yes, sir.
Yes. Okay. So just general instructions that every presenter will be given 10 minutes for their presentation, and the feedback will be discretionary to ma'am. So without further ado, we would like you to start your presentation. There will be a timer. We'll be giving you a time at 10 minutes over. We'll be telling that 10 minutes over.
Sure. Uh, I cannot open my video camera. It is shut down from that side?
Uh, yes. I'll just
Okay.
do it.
Can I start my presentation? Otherwise, hello, hello.
Yes. I'll look
Can I
into it.
still? Yeah. Can I still start the presentation? Because
No, it is. We suggest and encourage turning on of camera. Is there a problem
yeah.
on your device?
No, it was turned on, but then right now I'm not able to do that. I think it is turned off from your side.
But okay, we cannot delay anymore, so it's fine. You can start.
Okay. Good afternoon, ma'am. Good afternoon, everyone. This is Advocate Nandini Shahasane. I'm a practicing lawyer in India, especially in IPR and cyber law. Uh, am I audible, ma'am? I think I'm audible. I'm audible enough. So my topic of presentation, I have written a paper on gender dimensions of cyber harassment. Is the theme of today's conference, and I have submitted my paper on analysis of presumptions of digital evidence through the lens of cyber violence. To start with, I want to highlight that a law gets birth in the social fabric. So when we speak about any legislation, it never be an ideal legislation. The law represents a society's mindset. So considering Indian legal system and current situation in which we are dealing, the laws related to laws governing the cyberspace, uh, highly lack in administrating of those offenses. The cyber offense is a criminal offense, and it takes police action. And when the case goes before the court, it needs to be proved. The burden of proof is on the prosecution. uh, the crime is proved based on the evidences, based and there is the real need, that there is a there is a requirement that there should be, uh, the a particular offense should be properly defined so that a legal action can be taken properly, and accordingly the procedural laws should be also very much clear about gathering of the evidence, especially when we talk about electronic evidence while dealing with the cyber offenses. So I have highlighted the evidentiary part of the cyberspace, and when we are considering the gender biased or gendered nature of the cyber offenses in India, we focus on cyber offenses related to women. uh, One major aspect here, that currently we don't have any such law which deals with laws governing rights of transgenders or the third gender, we say. Currently we have, when we talk about gendered laws, we basically talk about the gender biases on cyberspace related to women. So there are, and why the topic is why we need to discuss this topic? Because most of the offenses they are happening against women, maybe dating app related offenses, matrimony related offenses, um, providing obscene material, and morphing, deepfake, then cyber stalking. uh, we mostly we see that the women are the most of the victims are women. Considering that the the laws in India, the previous laws and the recent amended laws, they there are provisions related to um, women centric laws, but the main hurdle is in the adjudication, that when the law there is a legal provision, but a person can get justice only if that offense if the person if the provision for offense is, yes, it is there, but what about adjudication? When the case comes before court, whether we are able, whether the Indian legal system is able to give justice to that victim, the answer is in most of the cases, no. Why? Because there is a presumption that if in cyberspace, when the offense comes before the court, what happens, that generally the say of defense, the take of defense is that I haven't sent that information. Because in case of a cyberspace, generally the IP address is tracked, and then the owner of the IP address is the accused. But the defense of the accused is that even though that it is my IP address, but I'm not the same person. So that is the general presumption when we talk about the evidence. And in when and the based on such kind of a presumption, uh, in most of the cases, the accused he gets scot free, and there is not there's a least possibility that the real offender gets caught. So my paper presentation is my limited effort to highlight this lacuna in the Indian legal system. And there is a requirement of solution from the legislators. It is a duty of the legislator to provide the remedy, because especially when we talk about cyber laws, cyber offenses related to women, if there will not be a prominent a very strong legal system to stop these offenses against women, it will mainly deprive women from access to internet, from access to cyberspace. Because if such offense is happening against any woman, what happens at first, that she's getting herself removed from the cyberspace. And that we in when we are talking about developed India, and India making a superpower, in that case, if you are if this is happening happening with respect to half half of the gender of the of the India, then we cannot expect any progress without women's participation in every sphere of the in in all the areas, actually, without women's participation. So that's why the topic is really important, and it needs to be looked after by the legislators. So I rest my presentation there. If there is any question.
Um, Nandini, can you just repeat the title of your paper, because I can't see any presentation, PPT or
Uh,
anything.
I had submitted the PPT. I
That's
thought it
okay.
is
That's fine. That's
uh,
fine. Can you just repeat it
okay.
again?
Yes, it is analysis of the presumptions of digital evidence through the lens of cyber violence. And the
Okay.
theme is gender dimensions of cyber harassment. So as a gender dimensions, I have considered
Okay, so my question to you,
cyber.
Nandini,
Yes.
I really like the topic you have chosen, but My question to you is that right now you said that there is a lacuna in respect to the cyber laws concerning the gender disparity in India, and you also focused on how, let's say, people try to creep into the private space of women and disturb them with objectionable content, or we can say a misbehavior for that
Hmm.
matter.
Hmm.
But what are the suggestions, uh, according to you, which you would want to give for such lacuna?
Uh, yes, thank you for that question, ma'am. In this article, I haven't given any suggestion because it is a small effort to highlight the situation, seeing that the law has amended IPC, CRPC, and Evidence Act has amended, but the lawmakers haven't given any remedy for that. So it needs very concrete change, which requires more deep thinking in the process. I have taken efforts just to highlight that the and studied the current Evidence Act. So I think giving suggestion will be very higher of me to right now to express on. But yes, giving suggestions that procedural law, CRPC should develop such guidelines where uh, collection, storage, and then treatment in general, treatment of electronic evidences should be written. The modes of the methodology should be written, should be codified, so that the police machinery and investigating machinery should act properly. And when the proper legal procedure is there, proving that crime before court of law will be easier, and very what we call very um, like there will not be any lacuna left while at least following the procedure which
Okay,
is
Nandini,
happening.
sorry to
Yeah.
interrupt. There's just one last question to you. You
Yes.
also mentioned how women, when they are harassed or bullied on internet, most of the women, they tend to leave the private space. Uh, what
Cyberspace.
do you think? Where is the problem with respect to the laws? Because there are so many laws already which we have, and you're talking about the procedural aspect, which only will happen when we go to the court. But then in
Yes.
between, what is the problem? Why do women tend to, just leave um,
Ma'am, this is a
private
so
space?
yeah, ma'am, that is very much social thing rather than a legal thing. What happens, like if we, okay, I'll put it in this way that in case of India, whatever I have studied, that if I'm from urban city, so if cyber offense, like somebody sending a nude photo of mine which is morphed, and if there is a video which is deep fake of with using my face and everything, so I will be very content, and I can simply say that I will not fall prey for this blackmailing, because I know the law, I know the things, and the society around me, it is quite supportive. But if it is in case of a tier 2 and tier 3 cities, so in those cases there are incidences of even suicides and breakage of their marriages because of such incidences. And so that is the situation. So that is happening, and that's why I said that when a cyber offense is happening against women, it is more sensitive than if it is happening against other gender, because women are otherwise considered as a weaker sex, considering the Indian society right now, and they are falling more prey to such blackmails, such um, cyber offenses. So that's why that was my stand, ma'am. Hello.
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 Yes.
Can you hear
Also,
me? Yeah, yeah.
yes, ma'am, we can hear. Sorry
Yeah,
to
that was
interrupt,
a
but
good
other.
presentation. I really liked how, Nandini, you have enhanced on the practical aspects of the problems faced by women on the internet space. Thank you so much.
Thank you, ma'am. Uh, Thank you.
Just thank you for the presentation. Just a reminder, other participants cannot ask questions to the other presenters. So now we shall also, I would request ma'am to please fill in the score sheet after each presenter. And when she's done, please let us know so we can move to the next presenter.
Can I leave the presentation room or should I stay?
So you have to stay.
Okay.
Okay.
Uh, we're done with the marking. Can we proceed with the next presenter, please?
Yes, ma'am, definitely. So moving on to the next presenter, Janvi Gopulani.
Yes, sir, I'm present.
Yes, we would request you to please turn on your camera for the presentation.
Yes, sir.
Yes. Yes, you may begin your presentation in three, two, one.
Good afternoon, everyone. Good afternoon, ma'am. Thank you for joining me today. I am Janvi Gopalni. I'm from Damodram Sanjeevaya National Law University. I'm a fourth year law student. I am excited to present the paper authored by me titled Data Privacy Laws Shield Against Gender Data and Algorithmic Bias. Diving right into it, into the world of data privacy, algorithmic bias, gender disparities that persist within AI systems. In this digital era, where the personal data of users is collected relentlessly for targeted advertising and marketing, data is traded as a commodity. It has got economic value. There is an ongoing discourse that data should be, whether the data should be considered as a good or not, also. So, this massive amount of user data that is collected from every online activity of an individual, ranging from internet search to a simple like on Instagram reel, this data is stored and it is utilized through machine learning techniques and it is processed on large scale. It makes a digital profile of the user, and this is increasingly being used by businesses for targeted marketing and advertising purposes by specifically serving these personalized advertisements and content. We may think of it as, oh, they are reading our minds. Instagram is reading our mind. But this is the background of it. While personalized content may be convenient, it definitely comes with a price, that is compromise on our privacy. So the present research explores the handling and processing of this personal data, especially gender data, by these data controllers, and the resultant algorithmic bias, which refers to the decisions made by AI systems that lead to unfair outcomes. When these algorithms are trained on specific data sets or specifically sensitive data like gender data through machine learning, AI system usually tends to mimic and reinforce the biases that are present in the data sets, which are representative of the society. This leads to the discriminatory and unjust results, though inadvertently, but consequences are immense. Uh, this paper examines the issues within the context of international framework that is presently in existence, the regulatory framework internationally. Specifically, I've concentrated on GDPR regulation, General Data Protection Regulation of Europe, and India's very new data privacy legislation, Digital Personal Data Protection Act. I have identified few regulatory gaps in specific areas where Act needs to be strengthened for mitigation of this AI related concerns and biases. So, to begin with, let us understand what algorithm is. It is a very sophisticated tool for automated decision making that is done with the help of massive data sets that are at its disposal. These algorithms typically draw inferences concerning individuals, their identities, demographic attributes, sexual preferences, and other instances. Uh, uh, Due to this, it might inadvertently perpetuate and mimic existing societal prejudices and stereotypes that are present inside this data, leading to a systemic bias that systemically impacts a certain group of individuals. I'll give real world instances where AI bias has been noted, such as Google Photos misclassifying black men as gorillas, and Facebook recommending primate related content to users watching videos of black men. It is observed that visual recognition of AI tools, visual recognition
I think Janvi is not audible.
Is consistently associating women with certain professions, such as nursing in this case, or maybe nanny, babysitting, etc. And AI systems, as a result of this, may reinforce the occupational segregation and perpetuate the outdated social stereotypes. Persistent usage of such language may lead to internalization of these stereotypes among the users and public, and may lead to shaping of public perception around it, and it might also discourage individuals from pursuing professions such as nursing in this example. uh, Nowadays, AI is also involved in hiring process. These algorithms may show preference towards one gender over the other in hiring, leading to unfair outcome. The perception that is generally present is that women contribute fewer working hours as compared to their male counterparts. So pay is also dependent on AI decision making. Consequence of this is that person is unfairly denied job opportunity based on algorithmic decisions. So, in the context of India, if we look at it, considering the immense cultural diversity and existence of numerous, innumerable societal biases that are a result of diverse population, tackling these AI-related concerns can be quite challenging. So, let us now see whether international regulatory frameworks for data privacy that are existing currently are effective shield to these AI-related concerns or not. So, in AI-related context, international context, notable initiatives such as GDPR by European Union, it was enacted in 2016, and it is regarded as world's most comprehensible and robust data privacy and data protection law. GDPR in particular addresses algorithmic bias through provisions such as right to explanation, consent is considered paramount, data protection impact assessment standards are provided for, and there is a mandatory requirement for fair data processing. GDPR is also known as the Constitution of Data Privacy Laws because several countries have their own data privacy legislation, and they've been heavily influenced from GDPR. GDPR also contains significant penal provisions, which, if data breach is caused, it entails significant fines imposed by data protection authorities called DPAs. Now, turning our attention into India, where there was always a lack of specific law addressing AI related regulation or challenges. However, recently enacted DPTP Act assumes a pivotal role governing the processing of personal data. So, this act notably brings forth the notion of special data fiduciaries, which process the personal data, and they are mandated to put in place suitable technical and organizational measures to ensure adherence to the standards and safeguards that are proposed in this legislation and to minimize the breaches of personal data. I have compared GDPR with DPDP and highlighted few regulatory gaps, and I will highlight one of them in the presentation now. GDPR identifies special categories of personal data, that is extremely personal, critical, sensitive categories of data such as racial, ethnic origin related, political opinions, religious beliefs, genetic or biometric data, sexual orientation related data. All of these are extremely sensitive, and compliance requirements that are there for these are very different from general personal data. However, DPDP Acts does not make any specific categorization. It takes a broader approach, lacking specific categorization for sensitive data like gendered bias in this context. So, this is a regulatory gap, one of which I highlighted in the presentation, and others are there in my paper. There is a need for international best practices to be inculcated into India's context, considering how diverse Indian context is. So the absence of specific provisions addressing these biases uh, uh, needs urgent interventions, and it is required that these biases are rectified through robust legislations. And the my paper also recognizes that the current discussions on generative AI and AI related concerns are overly dependent on corporate self regulation and voluntary codes of conduct, which in my opinion are insufficient. There is a need for consistent hard legislation which entails severe penalties considering the significance of the infringement. So I this would guarantee, I believe, a more efficient and supervisory structure which enforces responsibility in AI systems. With this, I conclude my presentation. Thank you for your time and attention.
Is Janvi, am I audible?
Yes, ma'am.
I really like the topic you have selected for your paper.
Yes, ma'am.
So I would want you to tell me, have you gone through the DPDP Act like thoroughly?
Yes, yes,
Yes.
ma'am. I have.
So yeah, so I went through your paper and I saw that how you have talked about how the AI tools, they are not gender neutral, right? You have given few examples also with respect to the credit card and all. But as per my knowledge, I think DPDP Act has tried to cover after the Nalsa judgment with respect to at least the pronouns being used. So what do you have to say about it? Is it like a landmark change which we are witnessing, or do you think it's just a bare minimum which we could have expected from the act?
Ma'am, it is definitely a significant change considering before DPDP was ever enacted, there was no comprehensible legislation that addressed AI related concerns at all. But DPDP effectively addresses a lot of AI related concerns. But considering the fact that technology is rapidly evolving, there is AI related risks associated with this rapid development of technology that are requiring significant attention right now. But I don't think DPDP contains such comprehensible categorization of specific sensitive data. For example, I've given GDPR categorizes specific data, classifies the data as sensitive, general personal data of a user in this way. But DPDP has no such categorization. It becomes vague when that categorization is not there. I've concentrated on gendered data bias, but gendered data could be related to sexual orientation as well. It could extend to that area as well. So if that specific concern is not addressed in DPDP, it might lead to regulatory gaps, as I've highlighted. So if even these inculcating international best practices and continuously monitoring policymakers are giving attention to these details also, it would be the best regulation.
Okay, just give me your opinion because you have actually highlighted a very good lacuna. But then, how do you expect that we balance the lacuna of protecting the personal data and having a gender neutral approach for these acts?
Uh, Ma'am, mostly the data controllers or data fiduciaries that collect our data, there are various fairness principles that consent has to be taken of the user. And there are different self regulation codes, voluntary codes of conduct, but there is no specific hard legislation that is consistent with every data breach. It entails a severe penalty. If such if such framework is provided, every data breach, significant infringement can be identified and it can be curtailed. So in that way, I feel that it is necessary.
All right. Thank you. Good
Thank
presentation.
you. Thank you, ma'am.
Thank you for the presentation. Uh, Ma'am, please let us know once you're done scoring.
We can continue with the next presenter.
Okay, thank you, ma'am. So upcoming next will be Aditya Suresh and Mansi Biju for presentation. Are they there here?
Yeah, I can hear you. Is it possible that we can do it without the video? Like, we're outside.
We encourage keeping the video turned on as per the panelists, but if it's not possible, then we can proceed.
Okay, okay. Also, may I know that we have the PPT that which we have sent to you?
We could not hear you. I'm sorry.
Do you have a PPT like for presentation?
We have all the data that has been provided by the participants.
Will you be able to present it?
So you're asking if you could use PowerPoint presentation, screen sharing.
Uh, yeah.
Yeah, yes.
Okay, okay.
Okay, thank you so much. Thank you so much.
Yes, you may share the screen.
Oh,
No, like, is it possible? Like, since we're outside, we won't be able to present it. So we were thinking if we could, if it's possible, if we could do it.
So, what is it? Do you just want to go through the slides and not present it by speaking?
Sorry.
How do you wish to present?
Uh, is it possible for you to share the PPT, or can I just like present it, like present a topic just verbally?
You can share the screen and present.
no, no.
Okay.
Actually, what happened is we are out. We came outside, and we don't have the PPT right now in our device. So, is it okay? Like we just present without the PPT?
Yes, it is also okay if you wish
Yeah.
to present
Okay.
without the PPT.
Okay. Okay.
Okay. Thank you so much.
Okay. 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 A very good afternoon to everyone. So me, Mansi Biju, and Aditya Suresh, we both are fourth-year law students, and we wrote a paper on the theme data privacy in the 21st century. Our topic is a deep dive into the effects of emerging technologies in the matters of privacy. So I'll give an introduction to this. So data is an important resource in the 21st century because data helps us understand the consumer's mindset as well as the market. And it can help businesses structure themselves better, render more tailored services, and train AI and machine learning systems. So this data is stored by service providers. And the problem is that there are vulnerabilities that are faced by them while storing data. And these vulnerabilities end up creating mistrust in the minds of the consumers. That's where the concept of data privacy steps in. So, data privacy is the concept of one being aware where their personal information is being circulated. And if the data is breached, chances are the intruders may exploit their personal data to commit fraudulent acts and harass data subjects or even leak trade secrets. To steer clear of this, laws are implemented, and the laws will be explained in the later part. I will first get into the emerging technologies. So, firstly, I'll explain about blockchain technology. So, they are shared immutable ledger that facilitates the process of recording transactions and tracking assets in the business network. And data, so how it works is that so this data, it's initially broken into shards through a procedure called sharding, and this is encrypted via a private key, and it makes it very difficult for it to be viewed by the other nodes. So these encrypted shards are then replicated to prevent data loss at the time of transfer, after which it is sent to different nodes across the world and recorded in the blockchain ledger. So this helps in maintaining the records as well as synchronizing the transactions. And also it saves the data and makes it immutable. Then we have cloud computing. Cloud computing is the concept of outsourcing one's computing services via cloud. So it's basically cloud is a medium for accessing files from anywhere through the web, and it saves on upfront costs as well as the problems of owning an IT infrastructure. So an example would be Netflix, Spotify, Gmail. All of them they depend on cloud computing to run their systems. Then we have 5G. 5G is basically fifth generation, and that indicates the fifth generation of wireless cellular technology. So this facilitates activities such as faster downloads, low latency, and massive capacity. So an example would be so the 5G, it has brought a lot of changes in different industries. So I'll give an example in the automotive industry. So in the automotive industry, we can see that it's for connected vehicles. So 5G, it facilitates sensor sharing between cars. So for instance, in order to prevent the danger of aquaplaning on a slippery road, the cyber tires on the car, they will sense the danger and they will send that information to the cloud, and it is then alerted to the other cars of that potential danger. And then we have IoT, that is Internet of Things. So it's a terminology that is used to describe smart devices. Now these smart devices, they will have a sensor, software, and network connectivity. So it can gather and share that information. So this technology is prevalent from simple devices like smartwatches, speakers, home appliances to complex industrial systems. And then we have artificial intelligence. So it's basically machine intelligence. It stimulates the human behavior by solving and making proper decisions. So we can see the presence of AI like pretty much everywhere, from phones using the AI to process like data like snapping images or playing games, or we can also see it being used by the government or any high authority in tracking or capturing fugitives to safeguard the national interest. So, they use the AI facial recognition to help the authorities easily track anyone from the world. So now I'll come to the laws. So in the United States, now the US being a federal nation, they have federal laws as well as state laws. So some of the federal laws are the Privacy Act of 1974. So it establishes the laws on data privacy and it mandates consent from the users, and they communicate for what purpose they use it for, and to whom the third parties that have access to the information. And then we have the Health Insurance Portability and Accountability Act, that they draw special attention towards the data of patients, right? And then we have the Children's Online Privacy Protection Act that protects the data of children under the age of 30. Then we have the Bilali Act, and they focus on protection of data shared by users with financial institutions. Now I'll give it to my other speaker to do the rest.
Okay, so the scope of the majority of the privacy laws in the US remains consistent. Privacy laws applies to entities that conduct businesses in the state or provide products or services or that they target the consumers in that state. Among all the states in the US, California continues to have the strictest privacy laws. The California Consumer Privacy Act, the CCPA, deals with the right to know, the right to use, the right to offer, the right to non-discrimination. The legislation also puts an obligation on companies collecting and selling. Excuse me, can you hear me? Okay, fine. Uh, so the legislation also puts an obligation on the companies collecting and selling consumer data to safeguard. CCPA was later amended with the California Privacy Rights Act, CRPA, in 2020. CRPA did not replace the CCPA but added and rectified certain laws in the act. Now we'll move on to the European Union's perspective. It is the stringent and the most comprehensive framework that the EU formed is the General Data Protection Regulation, uh, that is a GDPR, to govern the data privacy within and outside the EU. With the introduction of GDPR in 2018, it required its member states to comply with the data privacy regulations. GDPR consists of provisions pertaining to processing of users' personal data by data processors. Article 5 to 11 states that the companies must secure consent from the user before processing their data and must explicitly communicate to the user the purpose and specify third parties that will have access to their data. It is also vital for the company to set a checkmark for non-consenting users. Now we move on to Article 17 of the GDPR. It states the users also have the right to erase or right to be forgotten, meaning that they have the utmost authority to decide if it should be on the interest of the making companies accountable to remove such data if necessary. So EU is also taking strides by becoming the first to propose the idea of adopting the Artificial Intelligence Act. The new AI Act is proposed to regulate the functioning of AI and highlights the prohibition of piracy. I would like to continue the speech very much.
Yeah, so then we go on to India's perspective. So in India, initially it was the IT Act 2000, and that was first passed. And also in India, there's an important landmark judgment, that is the KS Puttaswamy versus Union of India. So they emphasize a strong foundation for privacy laws. In this case, the court held that the right to privacy is a fundamental right under Article 21, but it's not an absolute right, and it's subject to certain justifiable limitations for the greater good of the nation and its citizens. So after passing this judgment, a committee called the Sri Krishna Committee, it was formed, and they formulated regulations regarding the Personal Data Protection Bill, which was later passed in August 2023, and thus forming the DPDP Act. So the newly enacted act, it does not explicitly mention anywhere about artificial intelligence, but the core principle and preamble of the act is to recognize the rights of the individuals and to protect their data by mandating the act of permitting processing of such personal data for lawful purposes only. I would
Thank
like.
you.
Thank you.
Uh, is it possible that can we leave the meeting?
Are you done with your presentation?
Yes, yes, we have just finished the presentation.
Ma'am, any questions? Asana ma'am?
Yes. So I think it's a very trending topic you people have chosen, but can you just make us aware about, uh, according to you, what is the best or which country has the best privacy law, which you can think is very progressive in terms of how India is handling their privacy laws?
Um, as far as we have researched, we feel like the European Union's GDPR is best among the other countries' privacy laws, as they have mentioned like on what aspects, on what situations the user's data should be protected, and they have the highest number of sanctions towards the offenders. And the PDP Act it has been it's not been enacted yet. I mean, uh, by this year, it should have been enacted.
Aditya, tell me one
And
thing.
yes,
With respect to the Aadhaar, because the whole debate over privacy somehow started with the Aadhaar card. So when we talk about the security number, let's say of the countries like US, it's very private and protected to every individual. Now, when we have DPDP Act, what is the current status of, let's say, I going somewhere and uh, anybody asking my Aadhaar card so casually and you generally give it to them. So what do you think? The Aadhaar number, is it equivalent to the security number of the US? How are we doing?
um, so ma'am, as we know that since our Aadhaar card is linked to all of our bank accounts and all the other personal informations are there in the Aadhaar card. Even if you give our Aadhaar
Aditya, you're not audible.
can you hear me?
Can the other participant answer on your behalf?
Hmm? Is it audible now?
Yes.
Hello, ma'am. Is it audible?
Yeah.
Okay. So since uh, the Aadhaar card has a lot of our personal details like bank account, etc. So if any other person gets our Aadhaar number, so they can use it for illegal purposes by using our name. So it can be compared to the social security number of the US. So as far as the current DPTP Act, we have seen that not we can just show our Aadhaar card the number like from the DigiLocker app. So they won't show the Aadhaar card number fully. It will be with crosses and show only the last four digits. So with that, they cannot show the full Aadhaar card number to other people.
Another question to you people is that many international development organization, they kind of provide budget support or
Hmm.
financing for any kind of project for recipient countries. Now, generally these payments are prone to corruption. They become vulnerable to corruption. And how do you think blockchain can help in curbing such kind of corruption?
So as we have mentioned earlier, blockchain is kind of secure. Like since it's in a decentralized manner, there is only one user who can able to access the data via the blockchain technology. So any other person cannot able to access from the outside unless that person has the private key. and it's very difficult to obtain that. And on top of that, it has the best level encryption, so it won't be that possible to get the to leak or get the details out of from the blockchain technology. And I hope that this technology can be used in the future for
All right.
majority of
Good.
the sessions. Yeah.
Okay. Good. Good. Good.
Thank you. Is it possible, we can leave the meeting?
That is what the pro bono club will tell you.
Uh, yes, all the presenters, after your presentation is done, you may leave, but it is strongly encouraged to stay and look at other people's presentation as well, as they're highly fruitful.
Thank you so much.
And
Thank you.
thank you for the presentation. And also, one of the main instructions right now are that there will be no more changes that will be accommodated in the schedule, because there takes a lot of effort to reschedule, and many of the participants who have been given slots again face problems and difficulties. So we will not be accommodating any changes. This is the only last change we are having. Next will be Naina, and after that we'll be continuing our schedule starting from Shrikant, after which will be Sakshi, and then going according to the schedule that has been given to all of you. Thank you. Uh, Hasana ma'am, can we move to the next presentation?
Yes. So, okay. Yeah. Please.
Yes. So next will be Nana. Nana, you may start your presentation in 1, 2, 3.
Just want to confirm, am I audible?
Yes, you are, Nana.
Thank you. Good afternoon, respected chair and one and all present here. Myself, Nena Churasma, and my topic is revolutionizing India's influencer landscape, a comparative analysis of ASCI's regulation and the potential of the France Influencer Act. So, mainly my papers is divided into number one, to know the impact of influencer marketing. Number two, to know the ASCI and India's regulations. To know number three, the France Act, and number four is the comparison part. So I have divided my slide as well accordingly. So the global influencer market in the globe is at around 10.39 billion, which is about to grow to 139 billion by 2030. And in India at present, it is uh, 12 billion, the influencer market, which is supposed to be at 28% by 2026. So why is the need for regulating the influencer market? So at present, only 2% of the cases are there where the influencers and the brands are able to show the evidence that their material is not having any problem or violating the IP and the advertising regulations in India. And according to the ASCI statistics, over 3% only advertisements do not require changes in influencer marketing. 97% of the advertisements do require changes. So the initiatives by ASCI. So ASCI is a self-regulated potential. Rights are also so as to make them aware. So according to the ASCI guidelines, they define influencer. So influencer is someone who has an audience, the power to affect their audience, raising decisions or opinions about a product around, or experience because of the influencer knowledge, position, or leadership competence. They have also bifurcated virtual influencers as well. So, and they have also given a regulating option to them that if they find that any communication or material which is violating their rights, then they can also approach ASI for the same. So there are other laws as well that regulate advertising in India. So the list is long, but due to the shortage of time, I'm just going to over through the time. So France. So moving on to France, which I have compared because France is the first country in the world to form a regulation on the form a act on how to regulate the influencers and the influencer marketing. So why was the need in France as well for the regulation? So mainly the act says that because of the short tentative nature of the products that they brand, the 24-minute story on Instagram, on Facebook, which is very short. So how to regulate it gets very difficult. And secondly, the existing legal framework was incompetent. So as the figure shows, so it I have just tried to explain that how the act is divided. So the act has two titles. Each title has three chapters, and further it is divided into several articles and sections. So there were several cases as well. Like there was one case of Mrs. Mangoli, which happened in that the influencer was selling a car insurance, and then it was found that the car insurance they had some mutual benefits, and it was a fraud case. And after that, they were fined as well with imprisonment of 30 months, and there were several many other cases as well. So the act has so they have also not been able to particularly define what influencer is because of the nature, because it's not just influencer term, there is digital influencer or virtual influencer. So they have taken two definitions of influencer. Further, they have defined responsible influencers in their act as well, in terms of which sorry. So the responsible influencers are those who have a label and they have adopted the degree of care which the act gives them to follow. And the person carrying out, so they have also defined the agent of the influencer as well in the Article 2 of the Act. Further, so the punishments in the Act are such that in Section 3, the failure to disclose the sponsored content, 75,000 euros fine is awarded. In Section 4, it further defines that false or misleading advertisement is there, then 3 lakh euros and up to 2 years of imprisonment is also prompted. That's the following paper also discloses the other punishments as per the sections. So why should India adopt the act? So basically, it not only just helps India to create a regulation, but it provides transparency. The France Act provides penalty for non-compliance with the guidelines. There are several other reasons, like it bans the promotion of products containing which are banned in other acts as well. Like if we take the example of tobacco or gaming apps and which are not betting apps, sorry. So what would be the advantages and disadvantages of adopting the France Act would be that it will create a limitation because of the if we adopt the act, it will definitely the major opposition in the France as well to the act is that it will strengthen the regulations, but it will limit the creativity part, the enforcement challenges and compliances, but it will also include transparency. Legal clarity will help the consumers and influencers for protecting their rights and liabilities, and standardized practice will lead to industrial growth because of the market. So the way forward could be that technologies can be addressed in this act, monitoring and enforcement well, training and awareness, as I said already. So something which the act misses out influencers which ASCI has, then the accountability and the penalty for the agents as well will be covered. So an emerging market reports also will be covered in that. Thank you.
All right, Nana. So you have covered ASCI and the requisites mentioned uh, in the legislature. I would want to ask you because the current trend where the influencers are actually endorsing brands, good brands, local brands, people who are trying to start their business through Instagram. Influencers are becoming a role or maybe a bridge to endorse those brands on internet, and of course because they are so famous, people do follow them and get influenced by these so-called influencers. But do you think that the ASCI has uh, made any changes according to the new trend of influencers with respect to the disclosure requirements under the act?
So definitely, ma'am. So basically, ACI is governing on guidelines, and there is no act as such. But they have given a whole 2021 guidelines report in which they have made it clear that they have to show the labels. But according to their statistics, only 7 out of 10 Indians buy products which are promoted by influencers. So the act will not only help in regulating it, but they give it a value that and for better enforcement.
All right, Anna. Thank you.
Thank you.
Thank you for the fine presentation.
I'm
Ma'am,
audible?
can we go to the presentation?
Yeah, please go ahead with the next presentation.
Okay.
Yes.
Next will be Shrikant Kulkarni, and after that we'll be having Sakshi, and after that we'll be having as per the schedule.
Yes. Am I audible right now?
Yes, Shrikant, you are audible.
Yes. Good afternoon. Right now, my research paper addresses the problems concerning to the relationship between GDPR and competition law. Uh, as India started new project that is a startup India, and which is subsequently it get failed, and it was recorded and well researched that the IBM and Oxford Economics that the more than 90% startups are getting closed within the 10 years of their establishment. That's surprisingly what it ignites to us. It
Shrikant, can
ignites
you please
and
check your mic? Your voice is blurring a bit. It's not
yes,
clear.
right now, is it clear right now? Yes, yes,
Yeah.
yes, yes. Yes. So, the 90% of the startups are closing or getting settled down within 10 years. The reason behind that, the simple, they are quoting the lack of innovations in the Indian startups. So, why the startups are not getting sufficient resources, sufficient data for the innovation. Right now the next situation is that in the era of artificial intelligence, data is become a fuel, and data is also source of the new innovation. Suppose we want to be develop the product, what is the consumer behavior, what is buying behavior of the consumer, addressing to the particularly that product we are innovating or we are developing. We need a data. Therefore, the data flow and access of the data to the new entrant is highly important in a digital age. However, the competition on the digital market is highly concentrated. The intermediaries as well as the existing natural monopolies in the market like Google, Microsoft are existing and they have a natural monopoly in the market. That is out of the scope of the competition legislations in the across the globe, not in just India. We are addressing now. In that situation, GDPR in the European Union was enforced. But at the time of the enforcing GDPR, the data portability norms is not particularly addressed properly. Even Article 20 of the GDPR having certain thresholds that the only in certain situations and technically feasible situations to the data controller, it compels to them only to transfer data from one platform to second platform. That means that is if there is not technical feasibility for the transfer of this data, the next new entrant cannot get access of this data. Now, from the consumer perspective, competition law and GDPR also interact with the consumer also. At the time of the interaction of these three layers of the legislation, the second stake of the competition law is also consumer. At that time, it also competition law also interacts with the GDPR in such situation that where data portability and right to get data portable from one controller to another controller is also important. Now I am quoting for the example for the same. That suppose I am using a Gmail, individual using Gmail, and want to move to the new entrant in the market that is so-called, suppose we presume that ABC email. So if I want to get a feasibility, move to the ABC and subscribe their uh, services, what I need to do, the sufficient and easy access and getting transfer my entire email and Gmail data to the new controller. If that is actually right given and coined by the GDPR. But at the time, Gmail will may ask for the technical feasibility, and that technical feasibility is not explained in the GDPR, and subsequently in the DPTP Act is also blind for the data portability and data transfer. From the perspective of the competition law, it is highly important to narrate and set the mechanism for the data portability, and that will open the floor for the new entrant enter into the market, as well as ensure the competition on the digital platform, and also ensures the uh, additional check to the national monopolies and making competition and promote the competition on the digital platform. Now, second line of thought will be also can be supported and strengthen this stance that with the competition jurisprudence that is already settled across the globe since 19th century. That is doctrine of essentiality. That is also addressed in my paper. That doctrine of essentiality, what it talks about, if new entrants in the market, sufficient things, sufficient goods, sufficient environment has to be provided under the name of the doctrine of essentiality. In that situation, it also prays that the data access for new entrants and fair data access in the age of privacy and overlapping interest of the privacy laws is also important to consider and analyze this text. In order to this analysis and in order to settle all these percolated domains, that is artificial intelligence, competition law on digital market in the era with specific reference with the algorithmic collusion, and moreover the context of the article 20 of the GDPR. In that situation, their interaction and overlapping interests are highly important to consider, and I am going to try and attempt to problematize all the texts involving in that gamut of the complex gamut of the regulations in privacy and GDPR. And more surprisingly, in the context of the Indian context, we are a developing nation. We have new IT hubs. They need new innovations, and for their innovation, they need the big data sets for running through the LLM, that is large language modeling, for development of the new AI related services, new AI related products and things in the market. For that, they need the fairer access, which is not granted and denied by the DPDP Act, that is new legislation, and subsequently that is not also ensured and set up mechanism for the GDPR. In both legislation, the complete absence in the DPDP Act and minimal access and minimal grant of the GDPR try and strengthen the monopoly in the market. So that paper, obviously, the one single research paper cannot address all these things. I am writing this paper for just for the problematization of this problem, and addressing this and narrating the problem, and establishing the dogmatic relationship between the competition law and its interaction with the GDPR regulations. That is all about my presentation and paper. Is there any question, please? It's floor open for the question.
Yes, I really like the topic. I mean, it's very interesting that you chose this topic. One of the questions which I would want to ask you is that you have discussed the concept of data portability, and you mentioned how data controllers can refuse and accept data portability. But then, obviously, it's a big threat to privacy. It's a big threat whether because from one controller it's going to the another controller. But then, can you please tell us, because any which ways we are giving consent for the portability, right? So how do we seek for the right to privacy when we are giving consent to the data controller? I would really want to know this.
Yes, that is fantastic and very deep question you asked. It's routing the privacy overlapping with the GDPR regulations. See, suppose I give a consent to the Gmail first for store my data. That consent is already given to the Gmail. Okay. Now the question is, when I have a right, that is consumer perspective right, to get transfer this same data with another service provider with seamless mechanism. Okay, that means there is no issue of the consent. You are giving already consent to the Gmail. Now I am coining this right and ensuring this right to getting transfer to another service provider, which is mimicking the same provisions and having a homogeneous goods and services. At that time, consumer perspective right in one notion, and another notion is for the controller to controller. For to controller, there is we are proposing a new mechanism for the same. Obviously, there are stake of the privacy was there, but already that data was getting published and getting for one controller is already given. If the similar like of the services is getting transferred or getting transferred without even my consent in deemed consent, there is no harm from the consumer perspective. Rather, it's helpful for them in point of that they are getting not locking in the same provision. Suppose if I get this right or another Gmail get right smoothly or without hesitation, that means there is no lock-in provision to continue with the Gmail services. Okay, rather it's getting benefited to the consumer. Even there is enforceability of the deemed consent for the similar kind of the services. Hope you are getting clarified for my submissions. You are not audible.
Okay, I said it's a very good topic and new insights for me as well. So yeah, thank you so much.
Yes, I would like to add something. Can I?
Yes, please.
Yes. As a developing nation, we Indians need to be appreciate to existing monopolies like Google, Microsoft which is cross-border actually and operating in the India. So data portability for the Indians, for the Indian news startups are immensely important. And despite that, neither research institutes, neither the CCI is not addressing this issue in their conferences. And then our new startups are getting discouraged. And we are talking about the startup India, and that the failures are rooted in the data economy actually. So that is my conclusion.
That's really good, Shrikant. Very good topic. Thank you for the insight.
Sure, thank you. Please move for the.
Thank you for the presentation. Ma'am will move to the next presentation. Yes. So Sakshi Gupta will be presenting next. And also we encourage all the participants to please use the material, the presentations, and keep all your cameras turned on. Sakshi, are you here?
Hi, so actually I want to present my PPT, but I cannot in my phone. It's showing either I can open my camera or I can share my PPT. So is it possible for you to share from your side?
We do not share PPTs from our side, but it's you can ask ma'am if she'll be fine with either you presenting or keeping your camera on, because you can have either of option. Ma'am, you're not audible. Your mic is off.
So sorry. I said you can present the PPT, and while we are asking question, I can look at your face. Okay, so that's fine.
Oh, okay.
Okay. Let us know when to start your timing for presentation.
Okay, so is my PPT visible? Is my PPT visible?
No, it's not.
It's not yet.
Okay, is it now? Hello, is it visible now?
It is. Please start, Sakshi.
Okay. So in today's interconnected world, cyber harassment poses a significant threat to individual safety and well-being online. Dear ladies and gentlemen, esteemed chair and respected colleagues, it's my privilege and pleasure to address you today as I present my paper titled Navigating the Labyrinth, Unraveling the Gender Dimensions of Cyber Harassment. My name is Sakshi Gupta, and I'm a fourth year student at Lloyd Law College, and I'm deeply honored to embark on an exploration of the intricate relationship between the gender dynamics and the pervasive issue of cyber harassment in our digital landscape. Moving further with the research question that I have come up is how does gender influence the perpetration and experience of cyber harassment, and what are the implications for developing cyber sensitive responses? Moving further with the introductory part, which has been divided into two parts, which is significance of examining gender dimensions and gendered aspects of cyber harassment. So, moving further with the first one, examining the gender dimensions of cyber harassment is of significance important for several reasons. Firstly, it shed light on the underlying power dynamics within online spaces by uncovering how gender influences both the perpetration and experience of harassment. This understanding is crucial for identifying and addressing systematic inequalities, ultimately working towards greater gender equality online. Secondly, analyzing the gendered aspect of cyber harassment allows for the development of tailored prevention and intervention strategies. By recognizing the specific vulnerabilities and needs of different gender stakeholders, can implement targeted measures to reduce harm and promote online safety effectively. Moreover, a gendered analysis helps in identifying barriers that prevents individuals, particularly marginalized groups, from reporting cyber harassment or seeking support. This insight can inform the creation of exclusive or inclusive reporting mechanisms and support services that are responsive to the diverse experience of all genders. Moving further with the gender aspect of cyber harassment encompasses a multifaceted examination of how gender influences both the perpetration and experience of online abuse. This analysis delves into various dimensions, including the types of harassment perpetrated, that motivation behind such behavior, and the differential impact on individuals based on gender identity. Understanding these gender dynamics is crucial for developing effective prevention and intervention strategies that addresses the unique vulnerabilities and need of different genders. Moving further with the literature review, it is further divided into two parts, which is cyber harassment and gendered perspective. The cyber harassment is a pervasive issue in the digital age, encompasses a broad spectrum of harmful behavior perpetrated through online channels. It involves the use of digital communications platforms to harass, intimidate, or harm individuals or groups. This can take various forms, including cyberbullying, online stalking, doxing, revenge porn, and hate speech. Such behaviors often targeted victims with malicious intent, causing emotional distress, reputational damage, and often sometimes even physical harm. The prevalence of cyber harassment has risen significantly with the widespread adoption of social media and digital technologies impacting individuals of all ages and backgrounds. Its societal impact is profound and contributing to a climate of fear and insecurity in online spaces and undermining trust in digital communication platforms. The second one is gendered perspective. When viewed through a gendered lens, cyber harassment reveals distinct patterns and experiences influenced by gender identity. Research consistently shows that women, girls, and gender minorities are disproportionately targeted for online abuse compared to men. Gender specific experiences of cyber law harassment often involves sexist remarks, sexual harassment, threat of violence, and the dissemination of misogynist or gender based hate speech. Perpetrators may exploit traditional gender stereotypes and power dynamics to assert control and dominance over their targets. Moreover, the intersectionality of gender with other identity factors such as race, sexuality, disability, or further interventions and preventions shapes individuals' experiences of cyber harassment. Understanding these gender dynamics and intersectional complexities is crucial for developing effective prevention and intervention strategies that addresses the unique challenge faced by different genders in the digital space. Moving further with the perpetrators, the profile is examining the profile of cyber harassers. Gender emerges as a notable factor influencing both the composition and behavior of perpetrators. Studies consistently reveal a skewed gender distribution among harassers, with male compromising the majority. Although instances of female perpetrations also occur, motivation driving cyber harassment vary widely, encompassing a range of factors such as desire for control, retaliation, attention-seeking behavior, or ideological convictions. These underlying motives are often intertwined with gender-specific dynamics, including social expectations and norms surrounding masculinity and femininity. The tactics that are employed. Regarding tactics employed in cyber harassment, perpetrators frequently utilize gender specific strategies tailored to their targets. Women commonly face harassment characterized by sexualized or derogatory language, threats of violence, or attempt to undermine their personal or professional reputation. In contrast, men can encounter attacks on their masculinity, targeted insults related to their gender identity, or efforts to shame them based on perceived vulnerabilities. These tactics are commonly deployed across various online platforms, including social media networks, online forums, gaming communities, and even dating apps, where the relative anonymity and wide reach afford harassers that means to carry out their abusive behavior. Understanding the gender distribution of perpetrators, their motivation, and the tactics employed in cyber harassment is essential for developed targeting interventions and support mechanisms to mitigate the impact and foster a safer environment for all users. Moving further with the targets. So differential targeting, gender plays a crucial role in determining who becomes a target of cyber harassment, with distinct patterns emerging based on gender identity. uh, Women's, LGBTQ plus individuals, and other marginalized groups are disproportionately targeted compared to men, often experiencing harassment that is sexualized, gender specific, or intersectional in nature. Case studies and examples further illustrate these dynamics, highlighting the ways in which gender influence the selection of targets and the nature of the harassment they endure. Impact on the mental health of the person suffering from these cyber harassments has can have profound psychological impact on its victims regardless of gender. However, the impact may vary based on gender identity and other intersecting factors. Women, for instance, may experience heightened level of anxiety, depression, and fear as a result of gender-based harassment, while men can face challenges to their sense of identity and self-esteem. Comparative analysis by gender provides insight into these differences, allowing for a more nuanced understanding of the mental health consequences of cyber harassment. Recognizing the gender dimensions of mental health effects is critical for developing targeted supportive systems, services, and interventions that addresses the diverse needs of individuals impacted by cyber harassment. The reporting and the responses. So, the challenges in reportings are gender-specific barriers often hinder individuals from reporting instances of cyber harassment, contributing to underreporting rates and perpetuating a culture of silence. These barriers may include fear of retaliation, concerns about victim blaming, or lack of trust in the responsive of authorities on online platforms. The implications of underreporting are significant as it not only denies victim access to support and justice but also allows the perpetrators to continue their abusive behavior unchecked. Addressing gender specific barriers to reporting requires proactive measures to promote trust, confidentiality, and accessibility in reporting mechanisms. The effectiveness and the recommendations. Effective support systems are crucial for assisting victims of cyber harassment and mitigating its impact. However, existing support mechanisms often fall short in addressing the specific needs of individuals based on gender identity and other intersecting factors. Recommendations for improvement includes developing gender-sensitive support services, increasing awareness and education about cyber harassment, and fostering collaboration between online platform, law enforcement agencies, and community services. By enhancing support systems, we can better empower victims to seek help and navigate the challenges possessed by the cyber harassment. Moving further on to the conclusion, there are three parts that I have divided the conclusion in. The first is what are the key findings. The key findings provides a comprehensive overview to the research, the patterns and insights.
Sakshi, can you please
The
conclude It's already 10 minutes.
Oh, okay. So, like, uh, uh, this the environment needs more awareness, advocating for policy changes, supporting victims, and fostering a cultural of digital civility and empathy. By working together, we can strive towards a safer and more equitable digital space for everyone. Thank you. Oh, ma'am, I'm done.
Yes. So you have dealt in brief with respect to the cyber harassment and the digital age with respect to the gender, specifying how I don't think you have dealt with trans. It's just uh, women you have dealt in the paper.
Yes, mostly male and female. It's a bit of uh, the perspective of the transgender or mainly how it's impacted on them. I have dealt more brief, like more detailed in my paper.
Okay, so I would want to ask you: are you aware of this recent, not very recent, but there was a huge chaos with respect to an app, Bully Buy, which auctioned um the pictures of women from a certain community, and it was a great, I would say, mishappening that actually occurred in India. And if you're aware of it, can you just highlight what was the lacuna in the Indian legal system that it made this happen?
Okay, so
Are
I
you
have
aware
not
of it?
heard of it. No, no, I have never heard of it. But there have been not just this app, but there have been various instances where the pictures of the women have leaked, or as we are in the digital age where
It
AI
was
works
not
and
just
the pictures
leaking of the
are being.
pictures. It was somehow, picking pictures from here and there, maybe Twitter, Facebook, different social media platforms. And there was I think, a startup or an app which was made by an individual who used to auction these women on that app. It is a grievous sexual harassment one can face. What do you think in certain and in such kind of cases? Where is the lacuna with respect to the cyber crimes?
So in India, even at the point of we do not have very rigorous laws related to sexual harassment. There are cyber complaints which can be registered, but there is also not a like a good lining for filing a cyber complaint in India, even as of now. And the thing that you are talking about, that is happening with deepfakes as well, as we are living in an age of AI, where any picture can be picked up and can be changed to some other person and can be sold like an auction. So India needs to work like the policymakers or people who made laws in India needs to work on this and make laws which could be better, not just for women, but could be gender neutral laws, which would be beneficial for men as well. Because as of now, India has much more laws
When you
which
say
are
gender neutral,
in.
uh, sorry to interrupt, can you hear me?
Yeah, yeah.
When you say gender neutral, do we have laws with respect to cyber crimes? When I say cyber crimes, is it gender neutral pertaining to all the sexes, and the definition of, sex and gender has been widened with time? So do you think it covers everybody?
But to an extent, still uh, there are chances where the person, if he is a male, has to explain himself that he was victim here and not the person who has committed a crime. But yes, India needs have more like work more on these kinds of laws so that they can be more effective. As of now, there are laws which helps people, whether be it of male, female, or a transgender or anybody from LGBTQ plus community. But these laws has to be more stringent and robust for it to work efficiently and in a better way.
All right. Thank you, Sakshi.
Thank you for the presentation. We'll move to the next presenter.
Hi, shall I start? Shall I present?
Yes, your time starts. One, two,
Just
three.
one
Stop.
second. Just
Okay,
one
one.
second. Just a heads up to all the other participants who are left. Kindly stick to the time which has been provided for the presentation. Thank you.
Just give me a second.
Tavishi, are you still here?
Yeah, just one second. I'm presenting my PPT.
Okay.
Yeah, shall I start?
Yes, please proceed.
So, good afternoon. Today, Sanya Rai and I have decided to cover the topic of female representation in the health tech sector in India. And we have addressed the research gap, which is the lack of any data regarding what is the representation today of women in senior positions in health tech sector. Sana, can you move to the next slide? So, in the health tech sector, about 80% of consumer purchase decisions are made by women. However, a remarkable statistic states that women health has been marginalized in the healthcare system and seen as a specialty. Despite having a significant representation in the greater healthcare sector, there is a clear gender disparity in health tech. In India, health tech sector, women only hold about 18% of senior positions and earn 34% less than men. And in this paper, we have examined the dearth of female leadership in India's biggest health tech companies and how it would affect the end products they generate and the factors that result into this inequality. So next slide. Women account for more than half of the workforce at private hospitals, but just 27.5% of leadership roles are given to women. They are highly underrepresented in the subsectors such as pharmaceuticals and biotech, and they hold only 7.5 leadership percent of leadership position in this subsector. A survey found that there is a bigger gender gap in senior executive positions in India's healthcare industry. In India, women account for about 29% of doctors and 80% of nurses. Yet they are disproportionately underrepresented in the leadership roles. Aiming to pursue a more nuanced study into the women in health tech and the impact of it on innovation has been the driving factor of our research. Next slide. So, to fulfill the objective of this research, we deep dived into 20 of the biggest health tech companies in India and examined through company reports and websites what was the female representation decision making roles in these companies. Next slide. So here were our observations. The apparent dearth of female leadership in hospital management sector demands a lot of consideration. Rectifying this issue necessitates that a comprehensive approach, including the implementation of gender-based policies, mentorship programs, and strategies, need to exist to break down any gender-based barriers in career advancement. We also observed a great disparity in female leadership in telemedicine and IoT-based softwares, which are used for diagnosing different diseases. The presence of gender disbalance results in the fact that none of these softwares are been created to address any female-centric issue. Rather, they have been addressed to consider male-centric issues or issues that occur to the general population at large. There is also a notable absence of female leadership in companies such as Bolt, which makes wearable devices to monitor your health statistics and your heartbeat. However, there is a considerably high representation in one of the largest health tech companies, Healthify Me, which demonstrates that there is a potential for great gender diversity within the sector, setting an encouraging precedent for others to follow suit. Next slide. In 2021, a mere 0.3% of India's venture capital funding went to women led startups. The founder of the She Capital Fund, which is dedicated to supporting female entrepreneurs, expressed that there is an unexpected difficulty of making a case for females and female founders. Despite evidence showing that women led startups generate more revenue, create more jobs, banks also remain hesitant, often requesting male relative signatures for loan applications. In a 2022 survey by Bharatiya Yuva Shakti Trust, revealed that over 85% of female entrepreneurs face challenges accessing loans from public banks. Next slide. So, across all age categories under study, women regularly show themselves to be more proactive and involved than males in seeking and obtaining and discussing health related information, which clearly states that there is a huge number of female in the consumer market of health tech products. However, the gender differences in the health tech companies have resulted in no nuanced innovation created for females themselves, which has also resulted in a huge untapped potential in the health tech market. And there is a need to address this gender gap so that the high amount of females representation in the consumer market could also be reached towards. Thank you. Over to Sanya.
Yeah, good afternoon, everyone. I'll take it from here. So in this part, I'll be talking about the existing policies that are in place in India right now, and also take a look at what are the gaps here in the policy making decisions. So it is really important to avoid any kind of simplistic examinations of the digital divide, in the sense that um, you should get the policymakers should get into the intricacies of policy make of the gender gap For instance, the underlying structural disparities between men and women, particularly in the areas of education and money, while formulating policies for women, because there's a complex network of obstacles preventing women from advancing in their careers and capturing leadership positions, as Tavishi explained. In this regard, a study by McKinsey and Company shows the correlation of gender diversity with profitability, highlighting that companies with greater women representation, especially at the executive level, where most of the strategic decisions are made, have shown better financial performance. One of the government policies in place is Niti Aayog's Women Entrepreneurship Platform, which serves as an aggregator platform hosting services and information pertaining to female entrepreneurs. So, this platform enables key partnerships for campaigns, workshops, and other such learning opportunities from industry leaders. And this platform helps in ways of funding, mentoring, and networking, business development services, etc. One of the other policies is the National Startup Award Scheme, which promotes women led startups among other special categories. It awards them for their purpose of bringing about a socio economic impact and being a role model for other businesses. Also, recently, some Nari Shakti initiatives have been announced in the Union Budget of 24 to 25, 2024-2025, and this is, I believe, is a step taken in the right direction. So basically, what I want to say is that the access to there are government policies, but the access to these policies is one of the other structural issues which hinder the growth of women. Next slide, please. Next slide. Okay, I guess there's an issue, so I'll just continue. So yeah, in this regard, we also have to look into femtech, which is basically female technology. And here, in there's a rise in femtech, and it has really impacted in reducing the existing gender disparities in the health tech sector. Femtech is actually used to refer to technological solutions to women's health issues, including diagnostic software, apps, devices, services, etc., such as commonly we know about the menstruation menstruation apps which track the menstruation cycle for women. So in this industry, the femtech industry, the underrepresentation of women in health tech, as seen in leadership positions, medical trials, etc., leads to various health issues that are unique to women, or women are being affected differently from men. And this area of research is poorly studied and understood. Um, for instance, mental health issues of women have been studied very little. So, therefore, women specific data research was crucial to better understand women's health. With the aim of closing this gender gap, femtech companies started collecting large scale women health data by catering to women's needs across life stages through technology driven solutions. Um, so femtech has really helped to penetrate into the some of the gender gaps in the health tech industry, and but this industry faces certain barriers such as lack of awareness and lack of empirical data as well, because women are mostly, because certain studies show that women are not very comfortable talking about their health issues, especially sexual health issues, etc. One of the other problems is funding, because femtech companies are mostly led by women or wholly owned women teams are there. So the gender biases come in, and they face funding issues. Lastly, femtech is
Excuse
has
me. Sorry to interrupt, but your time is up. You're way about your time. So can you please conclude?
yeah, okay. So one of the last barrier I would like to just flag is the user data privacy. uh, so all in all, women-led businesses, as mentioned by my partner, has an unmet credit gap, and all the research gaps that I have mentioned before, these need to be fulfilled, and femtech also should be promoted much more to actually fill the gap in the gender health tech sector. Thank you.
All right, can you please switch on your cameras? I think that would be better.
Yeah.
Yes. So, your topic deals with the health sector, as well as you have emphasized on women holding the leadership or taking the charge. And have you just gone through the country India, or have you done any comparative study?
So I would just address this. So our topic comes under the theme of gender disparity and health tech. And we have covered the lack of female representation in decision-making roles in health tech companies in India. So the reason why we've covered India is because in the US, there is already a study done by the Stanford School of Law. So we wanted to address something which has not been researched upon. And in India, female representation has not been researched upon at all. So that was our research gap.
All right. So, with respect to the health of women, and maybe the data which we have with respect to health of the women, as you said, um, what can you say about the abortion laws of India and how practical it is? I don't know if you have covered that, but I would really want if you can answer that here. Because as per my knowledge, the law of India with respect to medical termination of pregnancy is really advanced, at least in theory. But what is the practical aspect? And yeah.
So actually, we have not covered this area at all. What we have spoken about is we have focused on like the leadership aspect of women in the health tech sector specifically, and yeah, that's about it.
Okay. All right.
Yeah.
Can you tell me?
But
So,
yeah, so just to answer your question, yes, now have that we have seen that the Roe versus Wade judgment has been overturned in the US. US is considered to be the developed country, one of the developed countries in the world, and this kind of regression of, say, abolition of the right to choose whether you want to have a medical termination of pregnancy, even in cases of rape has been taken away. And obviously, since there is a federal system, so it is now up to the states, and many states have already implemented this. So I would say that obviously India is one of the most progressive laws, and it is very surprising because the laws were created way ahead of time. They were created in the 1980s, and India still allows and gives the choice up until 20 weeks of gestation for termination of pregnancies, and post that, upon the opinion of the doctor, you can still get the termination done. So and that is also, that opinion of the doctor is also put into place only because of the health of the mother, because after 20 weeks obviously the pregnancy gets very complicated. So the Indian termination of pregnancy laws are very, very progressive, and also abides by the right to choice under the Constitution.
okay, since you've not covered it, otherwise I would have really asked you another question pertaining to this topic. But I would really want you people, because you've covered a lot of things in it, maybe in another paper or maybe in this paper, try covering that topic also, because it's really important, at least in India. Apart from that, just one more question I would want to ask you. You were talking about this company Femtech, right? Is it an Indian based company?
No, no. Femtech is the industry. So Femtech has many other companies like, for instance, if you've heard about Flow, the app. So femtech companies usually makes apps or softwares to which cater to the particular needs, health needs of women only. So, like for instance, in our paper we dealt with cardiovascular diseases. So strokes affect women and men differently, but what is lacking is the research on the effects of this disease on women, because there are already apps and softwares to deal with it in general, basically, so to say, to deal with the general symptoms, but it affects a lot more to in the case of women. So that is what I have tried to analyze, that gap has to be filled.
All
So
right.
these
Thank you
yeah.
so much. Thank you.
Okay, okay, thank you.
Thank you for the presentation. Ma'am, let us know when we can ask for the next presenter.
We can ask for the next presentation.
Okay, ma'am. I would request, yes, I would request Daita TK to please open and your presentation.
Am I audible and visible?
Yes, you're audible and visible. Please use your PPT.
Is my presentation visible now?
Yes, it is. You
Okay.
may start your presentation in 3, 2, 1.
Thank you. A very good afternoon to one and all present here and our respected panel member. My name is Daita and I'm a fourth year law student at Shastra Deemed University, School of Law. And I'm the co-author of this paper titled Economic Empowerment and Cyber Equality, which is a study on the women's entrepreneurship in the digital landscape. Now, before I begin, I would like to inform the panel member that my co-author is unavailable due to family emergency and I'll be the only one presenting. So starting off, in the as we know, in the contemporary era that has constantly been earmarked by continual data revolution and technological advancements that have reshaped the entrepreneurial landscape, particularly in the realm of e-commerce, it is important for us to address the challenges that are faced by female entrepreneurs. Now, despite there being significant improvements that has enhanced digital accessibility, there's been a persistent digital disparity that impedes women's full participation in entrepreneurship. Now, entrepreneurship in the digital age is shaped by several nuanced dynamics. And it is important to also confront the intersection of economic empowerment and also cyber equality for that matter. It is crucial to recognize the various natures of the challenges that are encountered by women entrepreneurs, including structural barriers, socio-economic norms, and not to mention, needless to say, institutional bias for that matter. Now, despite intersectionalities given importance in entrepreneurship studies that our paper has focused on, it is found that only two dimensions are given its due importance and has overlooked the intersection of multiple characteristics such as age, neurodiversity, religion, and sexual orientation and gender identity for that matter. That is SOGI. And there is a need for more comprehensive understanding of intersectionality that considers not just the specific traits of marginalized entrepreneurs, but also the systematic backdrop of this intersectional discrimination for that matter. Our paper also has explored into the intersection of cyber equality and women's entrepreneurship within online spaces that has emphasized the influence of social media platform, digital networks, and online marketing strategies on the visibility and success of women-led businesses. We have also highlighted, most importantly, on the legal safeguards and the intellectual properties that are existing for these women, while also addressing the gaps that are in these legal frameworks. The main objective behind why we have done this is to raise awareness as to the laws that are existing that puts women in an advantageous position in the entrepreneurial digital landscape, while also highlighting on the fact that there are certain pitfalls in the legal framework as well. Now, in the last part of our research, we have also provided a roadmap for the way forward, and by offering implementable and practical recommendations so as to address these existing legal pitfalls. And as I mentioned earlier, by also raising the awareness for the available policies and benefits that are pre-existing for these female entrepreneurs, thereby, empowering them to thrive in the digital entrepreneurial landscape. And so this is with regards to the introduction part. Now, the research questions that we have dealt with are: how do these legal frameworks in India shape the experiences of women entrepreneurs in the digital realm? It becomes pertinent to address this particular question because legal frameworks plays a significant role in shaping the experiences of women entrepreneurs in the digital realm. It is important to understand how these frameworks impact the woman's access to resources, opportunities, and protection that is, I would say, essential for identifying the areas of improvement and also thereby advocating for policies that promote gender equality and empowerment in entrepreneurship. The second one is: what are the barriers and opportunities for women in businesses within the current legal framework? So, by examining these challenges and opportunities for women, we bring to light these systematic challenges and also areas for potential growth. The third one is: what ways do e-commerce regulations, laws governing digital business ownership, and intellectual rights hinder or facilitate economic empowerment and foster cyber equality for women entrepreneurs in India? So it is important because e-commerce regulations, that is the laws governing digital business ownership and the intellectual property rights, directly impact how women entrepreneurs are able to achieve this economic empowerment and thereby foster the cyber equality for that matter. So these are the three research questions that we have dealt with. Now, the methodology that we have employed herein is the qualitative methodology. And this has helped us delve deeply into the nuanced role of women entrepreneurs within the digital business ecosystem. And it has helped us capture very detailed data, enabling a thorough explanation of the intersectionality of discrimination. And by also examining several studies that have highlighted upon the cultural and social and regulatory factors that have um, emphasized on the barriers of these women's participation in the digital entrepreneurship. Further, we have also explored a part of our research paper also explores into the empowerment and legal dimensions across diverse regions such as Africa, China, and also Latin America. And it has also given us a broader understanding of the global landscape of how the women's entrepreneurship in the digital age currently exists. The findings and the suggestions that our paper has sought to offer are that we want to give potential legal reforms that can create a more supportive and gender inclusive environment. We have also emphasized on the urgent need for policy reforms, practical support mechanisms, and also cultural interventions so as to link between the current so as to place an emphasis on the implication of intersectionality in women in the digital landscape in terms of entrepreneurship, so as to bridge the digital gender gap that is pre-existent right now. And to achieve this goal, we have also proposed a range of measures, including affirmative action policies and also more stronger penalties for discriminative behaviors, for that matter. And we have also advocated for the promotion of digital infrastructure development in rural areas, and also recognizing the importance of ensuring that there is equal access to resources and opportunities for female entrepreneurs across several diverse geographical locations. I think it is a well-known fact that when we are going to implement something new in our economy or in our government, it is important to start from the grassroots level. It is important to raise such an awareness. So that's what we have advocated for as well in this using this paper. We have also identified certain initiatives like Mahila A Hath, which was introduced in 2016 under the Digital India, Stand Up India, and Make in India campaign that have played a very important role in empowering female entrepreneurs. Additionally, mentorship programs, business incubators, and accelerators have also been established to provide these guidances to support women-led startups as well. Additionally, we've also identified the Vigyan Jyoti scheme, and the scholarship programs such as the Pragati Women in Engineering, Science and Technology scheme, which is very, very similar to the STEM revolution that we have seen in so many years. There's been a lack of awareness and lack of and so much of ignorance as to these schemes and these policies that are pre-existing in our country, which hinders women from availing such opportunities and taking advantage of these opportunities so as for them to gain the empowerment that they deserve, for that matter. In essence, our overall goal is to foster a sustainable and also inclusive digital ecosystem for female entrepreneurs. We've not only delved into female entrepreneurs and the digital impact on them, but also the female entrepreneurs who are in the e-commerce environment, for that matter. Next is utilities and contributions. So the utilities and the contributions are, firstly, we have scrutinized the existing laws, we have identified the barriers, and we have also uncovered the opportunities for female entrepreneurs. This thereby becomes a critical analysis of the existing laws. Nextly, we have also given a practical significance for the stakeholders across all the sectors by providing valuable insights and policy recommendations. Then we have also then the next utility is that we have also turned our attention towards promoting economic empowerment and providing actionable insights as per the needs of the stakeholders, and also creating an inclusive environment. And mentorship programs also stands as an important facet of empowerment because offering guidance, supporting tailored solutions to unique challenges that are faced by these women entrepreneurs, especially in these rural areas. And through these programs, our objective is essentially to empower women to overcome these obstacles and also realize their full potential. In conclusion, our research paper has mainly spoken about the landscape of the women's
I'm sorry to
entrepreneurship.
interrupt you, but your time is up. I would like to ask you to conclude your
Yes, I will
presentation.
wrap up and
Thank you.
I'll wrap up in 30 seconds. Thank you. So the conclusion part is that we have basically not just identified the gaps within the legal framework for these women, but also we have given implementable and practical recommendations, and also identified that there are some pitfalls in the legal system that can be that can be bridged using these implementable recommendations. Thank you for your time and your patience.
Yeah. Daita, can you just, can you just repeat your topic once?
My topic is economic empowerment and cyber equality, a study on women's entrepreneurship in the digital landscape.
Just give me a minute.
So my theme is related to the contemporary development and trends.
There's another Daita also, so I was confused. Just give me. Economic empowerment and cyber equality. Okay.
Yes.
So you were talking about the economic disparity amongst the gender, and you also discussed about the women's entrepreneurship and how we face the difference or discrimination. One of
Yes,
the
ma'am.
questions
There are
which I
several.
want to ask you is, you, because what I find in your paper is it's more or less like a, I think, a social legal study, but it, it's inclining towards the social study. Um, I would want to ask you, you kept on emphasizing about the awareness amongst women about economic empowerment and then scholarships, and there are a lot of yojana and organizations. But then tell me one thing: have you gone through this concept of domestic violence, and what is the definition of domestic violence or domestic abuse?
Yes, I have. So
So,
domestic violence. Sorry, ma'am.
does it include financial abuse?
Yes, of course. When a woman is prevented from being given the finance by their family members, from their husband's side and things like that. Yes, it is a important facet of domestic violence. There have been several case laws that have also emphasized on this.
So, do you think there is any relation with the lack of women coming for the entrepreneurship and financial abuse of women after their marriage?
Most definitely. I feel like actually in our challenges, we have identified the fact that the one of the biggest challenge that women face our lack of finances and the lack of ability to access such finances. And I think it is an important facet, as you mentioned, that domestic violence does play an important role in that plays as a hindrance to women coming into the entrepreneurial forum.
How can you relate your paper with gender data and technology?
So our paper not only talks about how female entrepreneurs are affected by the digital landscape and its evolution, but also how female entrepreneurs on the e-commerce platform are affected. So we have talked about the legal implications on both these on these two-tier approaches, is what I would say. So that's why it is related to data and technology.
All right. Okay. Thank you.
Thank you so much, ma'am.
Can we proceed with the next presentation, please?
Good afternoon,
Yes.
ma'am.
We would like to call on Devki Datta Prasad and Prabhu Lavande.
No, it's just one name, Devki Dattaprasad Prabhu Lavanda, just one presenter.
Okay, okay, fine. You'll be presenting with your
Yes,
PPT?
I'll be presenting. Just give me a minute.
Okay.
Just for a moment, how many other participants are left apart from Devki?
As of now, we just still have four more participants.
All right. Okay.
Yes.
Please proceed with your presentation, Devki.
Is my slideshow visible?
Yes, it is.
Okay. So when I'm starting with this topic called gender dimensions of cyber harassment, we all know that gendered crime is very popular in the physical world. Like we hear of rape cases and while domestic violence against women very commonly. But due to the increasing cyber influence in our lives, this crime has also entered into the cyber world. The cyber harassment is largely gendered because of the following reasons. First of all, gender is an institution which has existed in our society for a really really long time. For any social institution to form, the people in the society have to perform an action frequently and cast it into a pattern. When the pattern is repeated in the very same fashion every single day or in a fixed time, it becomes a habit. And the pattern that is formed, it is typical to a certain person. Like for example, the gender roles are very specifically typified. If we look at the Indian context, most of the times we'll see that that women are engaged in the domestic chores, whereas men are mostly engaged in income generating tasks. So this is the institution of gender that is present in our society. Though this is a social construction, but due to our socializing process in our day-to-day lives, we internalize it to a very large extent. Though it is a social construction, we start treating it as an internal reality, and any deviation from this internal reality is not taken very kindly by the society. So one of the reasons for the gender cyber harassment is people who deviate from the gender behavioral pattern. They face trolling, cyberbullying, and cyber stalking on their social media accounts because they are not adhering to the norms set by the society. In general, institutions are very coercive. They legitimize their continuance by means of coercion. One of the ways of coercing people to follow the institution is by issuing sanctions against people. These sanctions have been issued from time immemorial, but due to the present circumstances in which the online realm is very popular, this
coercion has entered, or these sanctions are being put into effect through the online world. Women who do not adhere to how a woman should be typically behaving, or men who maybe like to dress up flamboyantly, are harassed very badly on their social media accounts, and are bullied and shown as if they're outcasts in the society. Another reason for gender cyber harassment is the inferior status of women in the society. Women in general perform mostly domestic tasks, mostly in India, that is the scenario that we see. And the domestic tasks are unpaid work. So the work that they do is unpaid, hence it is treated inferior to them, which also becomes a part of their status. They are treated inferiorly, and this misogynistic mindset is propagated very frequently by the patriarchal society that we live in. The gender differences are propagated by the patriarchal society. So if they want to propagate the gender differences further, they expect that the society should remain as it is. But due to the present online world, women are expressing themselves in the online world. They are being opinionated. They are giving their opinions. So because of this reason, it is seriously threatening the patriarchal society. And in order to reinstate the gender differences and to make women realize that they are subordinate and they require the protection of men, they are humiliated and harassed on social media accounts, so that the fear is instilled in them and they do not try to break the boundaries that are set on them by the patriarchal society. This were the And another reason is, first of all, these things have always been happening in the physical world, but people are opting, like harassers are trying to get into the cyber world because it is easier to remain undetected in the cyber world. They can create aliases and fake identities very easily, and also because of the online nature of the harassment, the law enforcement authorities do not take it very seriously. Many countries still do not have laws to prevent cyber harassment. There are many methods of this gender cyber harassment to be propagated. First of all is cyber stalking, wherein wherein women influencers and actresses have complained that they have been stalked by their fans in the cyber world, and this stalking has also transcended into the physical world, leading to them feeling very insecure and afraid. The second type of gender cyber harassment is cyberbullying, wherein people who deviate from the gender behavioral patterns are bullied and trolled very horribly on their social media accounts. Teenage girls are specifically targeted because they have very unstable minds due to the hormone fluctuations in their body. As a result of which, they do not have the mental capacity to bear something of this magnitude. The third method is catfishing. We have very often heard cases wherein women have been duped on dating platforms by men who pose to be someone else, and when they actually meet, they are somebody else. There have been cases where women have been raped, murdered, or looted in the physical world due to this incidence of catfishing. The fourth method is doxing. Now, in this method, there is the method that is used is the hacker hacks into the device of the victim, obtains certain personal information such as their contact details, and publishes it. Now this is a serious breach of the privacy of the individual, and it also puts the physical safety of the person, especially women and people belonging to the gender minorities, in a lot of trouble. The fifth method is trolling. Now, in trolling, we saw a case of Pranshu Yadav in November itself, wherein they were a 16-year-old queer child who committed suicide because they were trolled very badly on their social media platform for dressing like a woman when they were born as a biological male. So we can see what bad effects trolling can have on the mental health of a person. The the next one is cyber defamation, wherein we know that defamation is a tort which lowers the reputation of a person in the right thinking members of the society. So most of the times, female politicians or people belonging to gender minorities are defamed online because their opinions, which have the possibility of changing the tide of thinking, are not to be taken seriously by others. That is the reason their character is maligned and their opinions are not given importance. Identity theft is another sort of method that is applied, in which the identity of the person, maybe a woman or a person belonging to the gender minority, is used by someone else posing to be them, and they do some things which portray the people as unreliable, whereas in reality, is someone else posing as them. Now, due to the present world wherein metaverse is very common, there have been cases of harassment of metaverse characters. The avatars of females are groped and raped, which leads to a lot of trauma for the person controlling them. The metaverse is designed in such a way that the sensory experience of the person is heightened in such situations. So actually, they can feel these experiences more severely than they would do in the physical world. The next slide talks about the effects of cyber harassment on victims. So, first of all, it is a very serious mental trauma for the person, because a person
Please
sitting.
conclude.
Um, Let me just finish this up. I'll conclude in like 1 to 2 minutes.
All right.
So, first of all, the effects of cyber harassment are very severe. They severely traumatize the person mentally, because they tend to lose control over their own lives as someone else is intimidating them by sitting in some faraway place. It also causes a feeling of isolation as they lose their safe space on the online platform. And it also leads to loss of confidence as they are shamed on social media. The laws of cyber harassment in India are Information Technology Act, which deals with cyber harassment crimes, and also the judgment given in 2017 deals with breach of privacy, which means that the state is obligated to protect the privacy of the individuals. And also, the loopholes in the system are that it is a gender neutral legislation. There is no special importance given to women or people belonging to gender minorities. And also, there is improper regulation of social media, because social media does not mostly come under the realm of cyber harassment according to the laws. I conclude my presentation. Thank you.
Okay, Devki. So I would want to ask one thing. You have mentioned catfishing in your paper and in your
Yeah.
presentation. Uh, is catfishing illegal?
Yes, it is, because you're posing as someone else.
But do you think if I, let's say, make a, I don't know, maybe an Instagram profile with some other name, portraying that I'm somebody else, is that illegal?
It may not be illegal in the sense that there are some laws to make it illegal, but if you look at it from the lens of morality, it does not sound very correct. And also, the result which can be made out of it, like for example, the consequences of this act are very brutal, especially for women. Like, we have heard cases wherein
Yeah, so
wherein.
again, my question is that do you think that if I make a profile on Instagram with some other XYZ name,
Yeah.
can I be legally sued for that act of mine?
Well, I do not know of any specific legislation as such, but if you look at it in the broader context, it does amount to fraud, because you are posing as someone else.
So the consequences attached to the action
There
after
is
I make a
nothing
profile
specific in the
might
cyber
be
realm as
illegal.
such.
Yeah, but then catfishing itself or portraying somebody else on the social media till now hasn't become illegal as such.
No, but
Yeah.
it can be taken in the realm of fraud.
All right. Okay.
But there is nothing specific.
But if the consequences per se with respect to that profile comes in order to prove that I have done some fraud, then fraud. Otherwise, if
Yes.
okay, all right.
If it is undetected, then obviously.
So do you think it's a loophole? Can you hear me? All right. Can we start with another presentation because I've already
Yes.
asked.
Thank you, Devki. Next, sorry, yes. Now we'll be going to Pratham. Hello, am I audible? Yes.
Greeting esteemed panelists and my dear participants. So I just request the organizing team, like, please intimate when my half of the time is exhausted. So as I start with my presentation, when the topic for this paper publication was told to us, that is gender, data, and technology, the one thing which came into my mind was the recent development regarding deep fakes, and this drove me to my topic of the research, that is guarding her pixels, navigating the landscape of deepfake harassment in the age of technology, unveiling challenges and protective measures. As we know that a few years ago, technology came where you could alter the photos, videos, and also the voices of your friends and other
Excuse me,
people.
I just got disconnected during my session. Are there any more questions?
The next presentation had started, and the ma'am had requested that the next presentation be started.
Okay, thank you.
You may
Uh,
proceed with your presentation.
yeah, sure. So the thing is, as this thing came, it made us laugh. It made people make comic content, but we were unaware of the danger behind it. As the great economist Mr. David Waters has said, the potential benefits of artificial intelligence are huge, but so are the dangers. And recently, when the case of Rasmika Mandhana deepfake came, this thing highlighted, and it was also highlighted by our honorable Prime Minister, that how this technology is being misused to generate misinformation into the masses, and how much danger it inflicts on the rights of a citizen. My research methodology which I adopted in using this research was doctrinal methodology, under which you study different papers, you different writings and cases, and you do your research. And the main research question which is answered through my paper is that it is the investigating the effectiveness of current legal frameworks and regulatory measures in addressing the proliferation of deepfake technology. Moving ahead, I'll go into the introduction of what is this deepfake technology is. So when we talk about deepfake, it is divided into two words, that is deep fake, deep learning, and fake. So deep fake means when you generate a synthetic media using technology, using different photos and videos, and also voices of another person without their consent, and you create an image or you create a video which is totally different from the original one. This is in a common particular sense what deepfake is. As you can see that there are many examples, not even just in the normal course of a person, rather on higher levels, such as in around, I guess, during the COVID time, a video came up out of the Prime Minister of Belgium, where that the whole in the video he connected how environment and COVID things could be related, but that that after some time it was revealed that the whole video was AI generated tool, AI generated image. So you can see that how deepfake had reached not just the normal common people, but also those who are surrounded by such heavily guarded technology. Mostly, when we see, according to a research done by CIGI, that is Center of Intel Governance Innovation, 80% of this deepfake content, the victims are women and mostly young girls. And this drives us to the gender thing of our whole discussion, that how this method is used against them and how a strong harm is caused to them. If we move on, we can see that the influence of deep fake content on the full universal scenario. The first thing is impact on politics and majorly on elections. During elections, around 48 hours ago of uh, your election day, the rules are imposed that uh, no more campaigning can be done, but you cannot restrict internet. Misinformation on the last day also of election could deviate the whole result and could lead to a very big tragedy which could be happening during the elections. And these kind of things are generated by AI. Mostly these deepfake contents are generated and spread across WhatsApp or Facebook to the people who are going to vote tomorrow. And this is a very big threat to democracy. As we know, free and fair election is the basis of a democratic society, and if you are hampering that particular pillar, then it is a very what should I say, it is a very big backdrop on the face of democracy. And this should be stopped in a society such as India. The next content on which deepfake is mostly working is on our personal lives, on the lives of common people and on the life of citizen. By creating deepfake images, by creating, I should be specific, by creating pornographic images of women, it is a very harmful kind of a criminal offense which is done against those victims. This particular the other parallels on which the legal students such as us, we should be more focusing, that these contents could also be used as digital evidence in the form of these contents could be used as digital evidence in the courts. As many courts in India, there is a only, according to Indian Evidence Act, you could submit a digital evidence by just certifying by yourself that yes, this content was produced originally and it is accepted by the court. But when such a kind of evidence which is altered with the use of artificial technology is presented in the court, it hampers the whole judicial system. There are very few courts in India, such as example Karnataka High Court, which has given the guidelines that any digital evidence should first be certified by the forensic laboratory and then it will be accepted. But this has not been implemented to the lower judiciary level where most of the cases go, and hence it gives a big question that is the whole judicial structure is free of such things, and is real justice being delivered to the people. If we go to our next slide, that is about the concerns threatened by privacy violation. Privacy in today's world is a very privacy rights is a very big thing for a particular individual. In Switzerland, the Constitution of Switzerland has enumerated right to privacy in their constitution. In India also, we don't have a particular fundamental right such as right to privacy in the constitution, but because of judicial intervention and because of this judicial activism, right to privacy has been given to the citizens. And when you create such images, you are hampering the right to privacy of a particular individual. What then the question comes down that what are the regulatory challenges? We are having the Information Technology Act, we are having Indian Penal Code and many other statutes which protect people from such thing, but then also why such content is being released. The big thing is that according to IT acts, and particularly section 66E D, section 67A B, all these sections are majorly focused that once a person publishes anything from his computer which is obscene, which is kind of a pornographic content, then only this person is criminalized and then only this person is penalized. But there is no such particular there is no such particular legislation which only talks about such AI created materials and how to penalize them and how to stop them. So the main thing is that once the wrong is done and then the remedy is given, you should also talk about the preventive measures which can be instituted in this. As for a woman, if something is published, at that time only it is a very it is a harm to her prestige, it is harm to her respect. As we talk about the ancient story of Ramayana, where Sita, after giving the Agni Pariksha, also she was questioned by the people of the state. So we should also talk about preventive measures which could be implemented. In 2016, I would like to give a contemporary example that in 2016, a girl named Vishnu Priya, 21 years age, she committed suicide because of a morphed image of one of her morphed image which was semi-nude, which was published on Facebook. She committed a suicide, and this is a very grave thing on of our face in a modern society like India. When we go to our next slide, that what comprehensive regulatory structure would be brought and how can this be adjusted in the legal system. For this, the first thing is that the government should focus on such content and create a legislation, a particular legislation. It should be drafted just in should focusing on such AI generated things. And our honorable IT minister, Mr. Ashwini Vaishnav, who is also in charge of the railway ministry, he has given a statement that soon such draft would be prepared, and it should be noted that in that draft bill, enforcement mechanism, a robust enforcement mechanism should be available, because we know that the these tools which are used to create misinformation, it is very cheap and can be easily accessed by anyone. But similarly, the remedy should also be so cheap, and it should be so much accessible that a person could easily reach the authorities and should complain about this, and should have the right to complain about these things and get a remedy for. Lastly, we should talk about protecting individual rights. In a society, consent of an individual is very important, which builds up a big nation. So every individual, particular individual, should be protected from it. India literacy is increasing, but our digital literacy is not at par with other international nations. And in such scenario, government should bring those legislations and those mechanisms which protect people from these particular kind of offenses. And in conclusion, what I would like to profess here, that in conclusion there could be a twofold conclusion to this whole scenario. First, we should draw attention. I'll just wrap up in 30 seconds. In conclusion, there should be we should draw attention to the complex social dimensions of deep fake, such as pornography. And secondly, it need to be recognized the need for comprehensive approach to growing technical problems, and strive to establish an adequate normative regulatory system, and giving each person the right to action and remedy first priority with the framework or criminal law. That And therefore, I will just end this discussion that in the international scenario, US, UK, they all are bringing digital rules. They are bringing deepfake bills in their parliament, and India, with help of all them, should bring those things which are very adequate to us. Stephen Hawking said that in under 100 years, computer will overtake humans, but we should understand that computers and humans should be aligned with the same goal. We should build a digital India where technological highways should empower the citizens, but with the safeguard that their rights are also protected. Thank you so much. Uh, am I audible?
Yes.
Yes.
Pratham, so
Yes,
it's one
ma'am.
of the, I think, the only thing which everybody thinks of when it comes to gender data technology, as you started your presentation, is the first and foremost thing, at least as a woman, it would be the fake technology and the threat which we all are prone to. I just wanted to know, because you have covered what is deep fake technology, how is it um, evolving with time, and there are no such statute or legislation yet made to protect or prohibit it. I wanted to know that, is there any country, because in India, if at all there are any consequences attached to deepfake, then that could be punished, right? If
Correct.
at all it's defamation, or if it is selling my video as a pornographic video, that can be punished. But then deepfake as such, it's not banned or prohibited yet. Do you
Right,
know
right.
any country which has straight away, at least in writing, in statute, prohibited or banned, or strictly has, made a statute for the people not to do or make deepfake videos?
So, as if particularly we talk that has any country banned deepfake in their legislative system, we don't get an answer to this. But comparatively, Switzerland, as I talked in my presentation too, Switzerland on the index of banning such AI generated things is on first, because the very basic reason is that they have enumerated right to privacy in their constitution, and through this, the judiciary has interpreted in a very large scenario. Along with this, the government is there has also started many several they have spreading their awareness campaigns through which people are aware about the consequence of deepfakes, as well as they have also signed many policies with different big multinational companies such as Facebook, Instagram, so that the policy be amended in such a way that AI is restricted just to furnish the people, not to harm them. And as I also mentioned about a bill, deepfake bill, which is not yet presented in US, but once is it presented and passed in US, US would be the first country where deepfake would, in on paper, be banned.
All right. I would want you to go through the regulations of China also. It's very ironical because we don't see democracy as such in China, but then they have strictly banned, as per my knowledge, deepfake. Go through it if at all. We can discuss it later on.
Yeah,
But yeah,
sure,
good
ma'am.
presentation. All
Thank
right.
you for
Can
yes,
we?
ma'am.
Yeah. Can we start with the other presentation, please?
Yes, ma'am. Coming up next, we have Daita. Do we have Daita here?
Oh, yes. Am I audible and visible?
Yes. You're perfectly visible and audible. Please open up your presentation and let us know when you can start your time.
My co-author will be presenting the presentation. Just give me 1 minute.
Yes, yes.
I hope the presentation is visible to everybody. Um, a very good afternoon again to everyone present here. My name is Daita TK from Shastra Deemed University, and I'm a fourth year law student. And my co-author here is Nishta from Shastra Deemed University, who's also a fourth year law student. And today our topic is titled "Safeguarding Women in Cyberspace: Navigating Legal Avenues Against Cybercrimes on Personal Integrity in India." It is very pertinent to address this issue in hand in our current society, given its prevalence in our modern digital landscape. In our current era, technology has become a very integral part of our daily lives, and it is offered as convenience and connectivity. But with this, there's also been a rise in cybercrimes that target personal integrity, which is a very important facet of our right to life and personal liberty under Article 21. The cybercrimes that we have dealt with in this current paper are revenge pornography, deepfakes, cyber stalking, and cyber hacking, and its legal implications and incidents in the judicial platform. The objective behind focusing on these four crimes are due to its importance, prevalence, and also its lack of awareness, pitfalls in the legal system, and most importantly, its surge in the recent times. Each of these crimes do not only breach a person's privacy, but also causes emotional distress and reputational harm, or even worse, drives one to commit suicide. So, firstly, revenge pornography. This is basically non consensual sharing of intimate images or videos, often with the intent to humiliate or harm a person deceive them. So, this has been mainly highlighted in the case of West Bengal, state of West Bengal versus Animesh Boxi, and several other cases that we have also made an analysis on in our country right now. And we have also given recommendations for each of these crimes that I have aforementioned. Next, we have also dwelt into deepfakes, which are digitally manipulated videos or images that are created using artificial intelligence, which pose a serious threat to women's personal integrity. Now, the cases that we've dealt with not only include the celebrities, the recent surge in the celebrities who have been a victim to deepfakes, but also there have been several cases in the judiciary that they have pronounced, especially during these political voting times, where they have made such manipulated videos or images, and they have disseminated them in the general public. The next one is cyber stalking. Now, cyber
Bhavita,
stalking is the yes.
sorry to interrupt, but you have co-authored two papers, and now you're presenting the
Yes,
second paper.
yes, that's right.
Uh, that's not actually allowed according to our policy.
It's
I
not
was
allowed
not
in any
mentioned
of the
of this,
conferences. It's not allowed in any of the conferences. I'm also very surprised.
but I was not informed of that.
It's a general thing
So,
which is followed in any of the conferences you ever present. I'm not aware if
yes.
any university allows that.
Okay, but I'm very sorry. My apologies, but I was not informed of this. Even when I contacted the point of contact, also I actually confirmed whether my two abstracts were selected when I did not get a confirmation for the second paper, and I was not informed that I was not allowed to do two papers at the same time. So I assumed that this was allowed.
So the
Can you
point of
just
contact.
confirm with the organizers once again? We'll take a pause.
All
All
right.
right.
Arina Parvin answer.
Yeah, I'd like to call upon Arina Parvin Ansari to present a paper.
Am I visible and audible?
Yeah, yeah.
Yeah. Good evening, Chairperson. Good
Just
evening.
for a moment, I'm so sorry to interrupt.
Yeah.
The organizers, can you please tell me if I am supposed to mark the ITA for the next paper or not? Or are we just
Sorry, ma'am, I
making it?
couldn't hear.
Uh, Kindly inform me with regards to marking the same author twice or not. Thank you.
Yes,
We
ma'am,
can
I will inform you.
continue with the presentation.
Yeah. So, good afternoon, Chairperson. Good afternoon, organizing team. Good afternoon, my fellow participants. Let me share my screen. Is my screen visible?
Yes, it is.
Yeah. Thank you so much. So, my topic is my name is Aina Ansari, and I am a PhD scholar. Topic for my presentation is the social media deconstruction of LGBTQ rights, and it travels with the right to freedom of speech and expression. The idea here is that we know that the social media plays a very pivotal role in our lives, and it has provided the worldwide connectivity, and the community are connected through social media, and which is very much has popularized the online content, online trend, online cultures, and people are quite attracted to it. And the social media plays a vast role in shaping our opinions, our perceptions, and everything. So now here, one of the important things that I've noticed about is that how social media make that perception into the mind of people, and that's where the deconstruction start. The idea of deconstruction is that the text and the practices which are there and how they are conflicting. So now here, when I correlate this with the Article 19.1 of the Constitution of India, so it says that the right to freedom of speech expression, whereas one's right to freedom of speech expression infringes other right to freedom of speech expression. How so? Because there are two kind of people, one who are quite liberal about it, about the LGBT community. They are quite sensitized about it. They want to fight for those communities. And then there are people who are quite um, conservative. They don't want that. I mean, they have the kind of phobia. They don't consider LGBTQ as a normal people. They have so many ideas attached to that, which is all negative. So here, that's how the deconstruction started, that how social media in one place provides the protection to these people, and on the other hand, when we talk about that, how it negatively also affects their rights. So when I say rights, it includes the constitutional right, fundamental rights, and the human rights. So that's how I've started the topic. And now I'll move ahead with the research question. So my research question is that how far do the practices of platform affects LGBTQ fundamental right of freedom of speech expression? So if we see, there are lot many online practices which are going on, like hate speech, like privacy infringement, cyber stalking, bullying, online bullying, sartorial. There are a lot of aspects which are there, and then which is quite normal in online world, but which is also illegal, but has been popularized and being followed and being made by people. Now my other research question is that whether current regulation of social media platform has been successful in the protection of LGBTQ rights, freedom of speech expression, as we know that uh, people overseas and especially in India, people are not that comfortable talking about their gender identity. People are still in the closet, so because they don't because the society does not accept them, and that is the reason why there are a lot many lacunas which are there in the legal system, which we are yet to overcome. Now, the method of this particular paper is the doctrinal, but for the purpose of seeing that what is happening in the online world, in the cyberspace, a glimpse of netnography, I think that can be seen because I've observed social media platforms and how people react, what are their comments, how they post, the text and images related to LGBT community. So that's a glimpse of netnography can be seen over here. Now, moving ahead, the utility and the research contribution. Now, the idea is that before I prove that, it's really important to highlight the theoretical underpinning. So, like I said, the idea of LGBTQ rights, the most important thing is what are these rights. Now, these rights are not something special which has been created. These are the normal human rights, basic rights which has to be given. But the people, their perception of these people, consider them as different part of the community, giving the term of given the tag like minorities, or not treating them as equal, violating their rights. All these things has led these people to come forward, and international community, national community, to come forward and protect the rights of these people. Now, when we say the social media deconstruction of LGBTQ rights, like I said, that social media plays a really prominent role in highlighting the problems that these people were facing. And in the previous presentation we were discussing about the influencers, so influencers also plays a major role. Now these days, the people of LGBT community, they are coming forward, they are sharing their experiences, they are sharing their lifestyle, they are sharing that how uh, they the knowledge that they have gained from the social media, because there are a lot many activism which has started online only, and that has given them the confidence to come out, that has given them the connectivity to get to know more people up like them, and to have more knowledge about it and figure out what they are. So these struggle has been really eased because of the social media, and especially I would say that it's the generation Z which is like more open minded. And there have been surveys as well. If I focus on a specific survey which was conducted for Indian population, it was Ipsos research, and they have clearly said that the people who live in the urban areas, they are more acceptable to the LGBT community, and most importantly, it has been possible just because of the social media. So I guess this is one of the important aspect which has came out because of the cyberspace. Now, though the if we see the our scriptures, our literatures, there are a lot of traces of homosexuality was already there. The traces of third gender was already there in the ancient time, in the medieval time. But even today, if we see, and the same thing has been carrying on, but we don't have a proper regulation on it. We are still not able to provide these people the specific right. So now the negative aspect is that there are so many perception which is attached, like I said, but there are a lot many things that people have come up with, like their contradiction with the religious views, the culture, the legal system, because they have lot many issues with regard to adoption, marriage, living relationship. Then there are social conception as well. Then there are frauds and misrepresentation, um, bullying, pornography. A lot of things are being made against these people, and all their fault is that they just belong to some different like they have their own gender identity. So now these problems have even started taking place because social media provides the anonymity. So these anonymity kind of become an issue, because people just comment and they just forward it, and nobody knows who's the owner, who's the person who is right. So that's the problem, that which I think it's really important to talk about, and which is why I think that my research paper is one attempt to talk about these. So now what are the things that we can do to eliminate these kind of things and to make the regulatory framework more stringent. So like there have been effort which has been made by the judiciary. Like if I say there's a National Legal Service Authority India case, now Singh Johar case, uh, case, Puttaswamy case, all these cases have been really significant and really empowering in terms of protecting the rights of the LGBT community. And then we have laws like we have press media laws, we have broadcast media laws, we have information technology law, we have guidelines on the intermediaries. Now these are the additional laws which has been created, and that's specific to the feel. Like if the print media people, they are publishing something, now they have to abide by it. Same goes with the broad media, intermediaries and everything. Then other than these, we have digital personal data protection bill, which is about to come, maybe next year, most probably, if everything goes well. And then we have transgender persons protection of Rights Act of 2019. Now, so far we have created a legal framework to deal with certain kind of problems, but these certain kinds of problem does not address the problem of LGBTQ as a whole. So, which is why I think that it is really important that we sensitize people about these issue. Make the global awareness, make the social media platforms run such programs or channels so that people be get to know these people, their experiences, and how they are struggling, and they can also, get the support of the community. It's really important. Specific, I would say that there should be an online policing or something advisory which should be made by the government, national or international. It is really important to uh, make the reporting system rigorous, make the appeal relief system rigorous, so that these people, they can maintain their anonymity and still they'll be able to, report those contents which are against them. Additionally, if I talk about the specific recommendation, I would say that algorithm setting and the moderation of platform is really important, because most of the online activities and most of the social media thing which is happening, it's because that they follow their own thing. They follow that, we have our content moderation policy, we have our guidelines, and the government rely on it. But then what happens that that is not being properly followed. And am I audible correctly?
Yes, you're
Yes.
audible,
Yeah.
but your presentation
Yeah.
not audible.
Oh, okay. Anyway, so I was just talking about the recommendation that I was recommending. So I would also say that there should be the algorithm indicators. Now, these algorithm indicators that would also help for the platform users and the platforms, so social media platforms. So what they can do, these indicators can highlight the abusive term or something which is not socially or legally acceptable. In that case, what will happen, that these algorithms will figure out the problems, and then that will eliminate the first level. So there will not be such comments or, sharing of such thing which is quite common online. And other than that, I would suggest that the content moderation policy that government relies, that the platform has. So I think that content moderation policy should also be vigorously be seen by the government. And just for 1 minute, I would just like to conclude that it is really important to uh, regulate freedom of speech and expression, especially guided by the Article 19.2 of the Constitution of India, that the reasonable restraint should be there, and the social media platform should be made safe, following the fundamental right, and should not, people and the platform should not let other people infringe the right of the LGBT community. Thank you so much. Uh, if there's any question, I would love to answer.
Yes. So, Arina, you a very good. I think you have done a thorough research on this topic, so I really liked the data and everything. But I would want to ask one question in order to understand your topic even more, and it would help
Yeah.
the other participants to understand your topic. Uh, okay, so we understand the basic of it, that because of social media, there are chances that the LGBTQ community, which the platform is helping them, as well as there are chances that they are becoming a, I would say, victim to it. But then again, you also mentioned something like online policing.
Yeah.
Can you
Policing.
just
Yeah.
elaborate on that? What is it?
Yeah, so basically, some of the countries, they have come up with the idea that some of the, like, they have create, like the police, the way they do in a real life. In the same way, they have created some platforms, and these police, what they do, this they are vigilant about the content which is being posted. So there have been instances where they have figured out, okay, this person has posted this which is against the community guidelines, and they have blocked that person. So that way, I think that would be one of the best thing if we
So
often
I
do it, or
understood.
there.
Sorry
Yeah.
to interrupt again. So now the
Yeah.
question comes, the actual question comes. Um, in India, do you think this will actually help? Because countries or places like Nigeria, if you look at this concept, it is also helping the police to actually, catch
Yeah,
these people from the community, and they're again becoming a victim to such ideas where the
right.
police can actually navigate these people, or having a record of these people. Are you understanding my point?
Yeah, yeah, yeah. I
So,
understand.
do you
Yeah,
think that for countries like India, um, do we need such online policing, or do we need actually police who are maybe taught, or they're professionally sound to understand the whole concept? Because if you go through the Nalsa judgment, even the reputed honorable judges, the description or the contemplation of the whole idea or the concept of homosexuality, it's so confusing. I don't
yeah,
know if you have gone through it. So
yeah, yeah,
on,
yeah.
yeah, on one hand they're saying that it is by birth, and then on the other hand they say that it's according to their self determination. So the judges
Right,
are confused. So do you
right.
think that we require some sort of professionals in order to understand people from this community, in judiciary, in police enforcement agencies? Because you also mentioned that we don't want any special treatment. We
Yeah,
are like any other ordinary people. So yes,
right.
that's the question.
Yeah, on that, this is my personal opinion that I always think that why do we have to know them, that why their genders are, what their sexes are. I'm just like that, whatever they are, whatever their preferences and whatever they are, I mean, just like humans, can't we just accept them rather than getting into the legality? And we talk about the infringement of right, like I being a woman or the other person being the transgender or the other person being the lesbian or something, whatever the bad has been written for that person, or any image which has been circulated, or anybody's privacy has been infringed, so I guess that should be prosecuted. So
Okay.
my idea is that let's just go on the action rather than go on the identity of the person,
Yeah, but
if
then for all
that
of
makes
us, it
sense.
is, yeah, because in India, the social, I think, mobility is, or the social transition is too difficult for all of the
Yeah,
people to accept. So, don't you think that we would need somebody and people in different pillars of democracy to actually understand the concept? That is my question to you. Do we need
yeah, it is
professionals?
really, yeah, we do have cyber cells, but the problem is that cyber cells are not that much talk about, people don't know about it, people don't know how to go for it. And I mean, when I was in the university, one of my students, they have done a research and they went to cyber cell, and it was even difficult for them to take out the data. So here
All
the
right.
government can help. What I think that the IT people and the legal people, they both can mix, and they can create a committee panel or something like that, so that they can get the technical knowledge and the legal knowledge, and through that they can enforce the regulation and find out the culprits.
All right, Arina. Very good presentation.
Thank you so much, appreciate it.
Thank you so much for the presentation. Meanwhile, we are checking Daita's and Nishita's presentation, and we are checking if there has been a confirmation. We'll move on to the last presentation that we have, that is Akshita Gupta and Aman Siddiqui.
Yes.
Yes, Nishita.
So just a small query. Is it about the presentation or the paper itself that co-authored by the same person?
No, it is actually the confusion is over here, that whether the since two papers have been co-authored by the same person, so we were thinking of making an exception, but we're just checking if the confirmation mail had been sent to for this paper,
Yeah, it has been sent. I have confirmation paper for that. I
because
have the
Daita
mail.
said that she did not receive one, right? That's why she had contacted the POC.
No, no, no.
It
The,
just came to a different email, that's it.
Okay,
Because
so
we filled a
confirmation was there.
form. So I filled a form for my first paper with someone else through my email. The paper that I wrote with Nishta sent the email. I mean, the Google form was filled in with through her email. So we also got the confirmation for both the papers. And your student coordinator, Janvi Prashante or someone, they also confirmed me through text that both my papers have gotten confirmed.
Okay, definitely. I'll just look into it one more last time till we will carry on with Akshita's, and I'll
Sure.
just let you all know.
good.
Yes.
Thank you.
Akshita and Aman Siddiqui, please get ready with your
Yes.
presentation.
Okay, is my video visible? No.
Yes, it is.
Okay, I'm sharing this screen. Aman, can you share the screen, please?
Yeah, just a second.
Yeah.
Is the screen visible?
Yeah. Yeah. Okay, good afternoon, everyone. My name is Akshata, and my co-researcher Aman are from fourth year law school, Delhi Metropolitan Education, affiliated with Guru Gobind Singh Indraprasth University. Today, we are going to present a topic on evolution of data protection. Aman, next slide. Okay, data protection. Aman.
Just a second, just a second.
Yeah, no, not a problem. Data protection and privacy is intermingled, forming an exceptional sensitive domain within the legal landmarks of our times. This research paper is an analogous research method which deals from the need of data protection from the earlier times to the primary need that was needed in the widespread impact of COVID-19. We have through this time frame, we have seen a lot of changes that have taken place. We all know what data protection is, right? Data protection refers to the collection of information, regulations, laws, and practices that prevent privacy invasion, brought in the gathering, storing, and sharing of private information. From personal information such as name and addresses to sensitive informations like financial records, health records, have been awash with a vast ocean of information. In the era of collection of data, our government has collected these data on a large scale, including cooperative societies, corporate sectors, and various online platforms. But there was always a need of safeguard of individual privacy that have been there most of the time. Data breaches, theft, misuse of personal information have all underscored the importance of data privacy in our interconnected world. Let us move towards our first data protection act made in the country. That was the Information Technology Act 2000. Aman, please change. The Information Technology Act 2000 was made to diminish and completely eradicate digital crimes while facilitating trustworthy digital and computerized and online transactions in the country. The act has so far reached the impact in the Indian economy by enabling the growth of e-commerce and facilitating the ease of doing business. Information technology has also resulted in the growth of a country's GDP. And not only this, the act has also recognized the electronic records and digital signatures essential in enabling e-commerce transactions. It also helped in facilitating storing of digital information within India. Uh, Even though we have a lot of benefits while moving towards while talking about the IT Act, but there were limitations as well. Two of the most important limitations was first that this act gave unnecessary powers to the police officers to arrest people without warrant, and second that some cyber crimes like child pornography, online distribution of explicit content, videoism were not covered in the IT Act. In order to support these two limitations, I would like to talk about two cases. First, Shreya Singhal versus the Union of India, where two women were arrested because
Just a
they
moment. Can you just I don't like. Can you zoom in a bit so that we can read your PPT? We can't actually read it.
yeah, Aman, actually just do the full screen of this. Yes.
Yes. Now it's nice.
Aman, change the slide to the
Yeah,
third one.
just changing.
Yes. Ma'am, is it visible now?
Yes, it is.
Okay. So continuing towards the case law, Shreya Singhal versus the Union of India, where two women were arrested because they commented on a social media platform about the appropriateness of the strike which was held in Mumbai. The arrest was made under Section 66A of Information Technology Act 2000, which allowed police to arrest individuals who posted offensive comment online with the intent to cause annoyance, inconvenience, or danger. But later on in this case, this section 66A was considered unconstitutional. The second case, that was Justice K.S. Puttaswamy versus the Union of India. It was held that in this case, it failed to address other issues involving the use of data by children and the breach of data by companies outside India. As I already said, that IT Act talked about information within India and not outside India. Therefore, even after making so many amendments under this act, it led to the formation of another act, that was the Personal Data Protection Bill 2018. This bill was made to create a framework of laminating organizational and technological measures to lay down norms for cross border transactions, data with security, ensuring accountability, and provide remedies for unauthorized harmful processes. Aman, please take over from here.
Thank you. Am I audible?
Yes, you are.
Okay. Thank you, Akshita. So as Akshita mentioned that there's the previous bills that contain the problem of the cross-border transactions and all. So after that, Personal Data Protection Bill 2018, the government had made a committee, and they have formed a Personal Data Protection Bill 2019, which was proposed in 2000 December 2019, and it recommended that non-personal data and be regulated under the personal data bill, as well as in the legal framework should be followed instead of being separate legislation for non-personal data. And it is basically to provide security to the citizens. They stated that the protection legislation is to personal data and not only to determine the privacy issues. As but also the governing data protection is necessary to ensure, and also the data is under the one data protection authority. So after that, the new bill which was proposed, as it was the data protection bill 2019, which was struck down by the government as it contained the lackness of that. It cannot be the cross-border transactions which were not covered specifically in the 2019 bill. So after that, the government proposed the bill of Digital Personal Data Protection Bill 2022. The temporary object, it got recognition in 2023. It was a primary objective of this act was to comprehensive protection and providing a framework and processing of personal data. This act also provided for both processing of data in a manner that recognized both the rights of protection and processing of data for lawful purposes. And ma'am, in the in the emerging technologies that like India is governed, involving like the online transactions, which and the previous bills which were not covered the online transactions. So this bill had given a handful of opportunities and the power to the government, so they can tackle the cyber crimes and all, which is a major issues which are emerging in the cross-border transactions between the businesses. So the 2022 bill also aided the Indian businesses to enhance their working with other businesses across the globe while protecting their data. So, ma'am, in the international commercial law perspective, when the two commercial institutes are, entering a joint venture or having a business transactions, so nowadays they enter into a contract through online basis, and it's a really great chances of that the spammers can can do a fraud or all. So there was a striking need of that bill is to be formed, which is named as a Digital Personal Data Protection Bill. So under the bill, the section 2 clause G of mentioned the states that the concerned manager, which is registered under the board. Section 2 clause H defines data, a representation of facts and concepts and opinions. Section 2 clause J defines data fiduciary, a person. Just a second. Yeah, data fiduciary, a person who actually processes the data in the for the individuals and institutes. So the as we compared the previous legislations and the new digital bill, we can come to conclusion that the data personal data protection bill uh, uh, increased the fine rates, which was in previous bills. It was 250 crores, and now which is increased by 500 crores. And it also emphasized on the cross-border transactions, which was not covered in under the previous bills. and and then current sorry, actually, am I audible?
Aman, can you conclude because it's already time?
Yes, ma'am. Just a second. Just a second. Yes, ma'am. I conclude here by now that the Information Technology Act was a revolution in the online transactions act, as the online transaction which was increasing day by day. So India needed a codified bill which enhances or which gave power to the government as well as to the individuals, which created a, ma'am, which created a trust on between the people, that they, if they are going or surfing to the websites, their data is protected and they are not going to not being spammed by the individuals, or they will not be subjected to cyber crimes. So it also imposes the penalty on the individuals who are doing unlawful activities, and it goes on ensuring that their data is being protected on the websites in which their data is saved. So, ma'am, I have to cite a case, Facebook INC versus Commissioner of Income Commercial Taxes, Tamil Nadu, 2020, in which Supreme Court stated that the Facebook is not authorized or is not legally binding to store the personal data of an individual, or they can simply they cannot hold the data of a person under the Digital Personal Data Protection Bill. So it gave a reform to the government and the people, and in India, in which the emerging technologies as well as artificial intelligence is growing. And that in this bill, it is covered that the future emerging technologies, which is not yet known to human, which it will be covered by under the bill. So
All right, can I ask
yes,
the
ma'am. Yes,
question?
ma'am. You're free to ask.
Yes, ma'am,
Okay.
sure.
So, I really liked how you actually told us the evolution of the whole data protection bill, and it's a really nice, precise presentation. The question to you guys is that, are you aware of the Unlawful Activities Prevention Act, UAPA? Have you heard of it?
Yes, ma'am.
Do you think UAPA and this Data Protection Act, it's two contrary acts and it contravenes each other? What is your
Yes.
opinion on it?
Yeah, ma'am. I had to share a ma'am, incident. You are aware of honey trapping by the terrorists and other I will say enemy countries, which is they have to by targeting or them online, the armed forces and the officers of the armed forces. So, ma'am, I could like to relate that cyber crimes is it can be financial, it can be of some source of grabbing information, which is I think important to a country's security. So, ma'am, data protection bill uh, it aids that the data is not stored or it is not stolen from anyone privacy. So, ma'am, UAPA under the UAPA, it's Unlawful Protection Preventions Act, unlawful activities, and ma'am, this activity of honey trapping or the fraudulent activities of financial sector, it is prohibited. They are
But
doing.
do you think it is intimidating the truth seeking journalist or media?
Ma'am, I don't think it's intimidating, but of course, knowing about someone's private information is somewhere wrong as well in today's time, and we should prevent it somewhere or the other. That is why acts come into force after so many researches to protect such things, right?
And ma'am, in 2018 bill, the consent word was not yet defined. So the government had in 2019 bill, the consent word is specifically defined in the bill. If anyone is storing or storing the information or the data without the consent of a person, it is termed as unlawful.
All right. All right. Okay. Good.
Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank you for the presentation. After talking to the main OC, core OC, we have decided that we'll be making an exception for Daita and Nishita. So once mom is ready, we'll be ready to
Daika,
start
can
the
you
presentation.
start from where you left?
Yes, absolutely, ma'am. Thank you for making this exception for
But
us.
just a heads up, Daita, because there might be some miscommunication on the part of the university. But then I just want to suggest you, because you people are students, and it doesn't happen in general, because you got a communication from the university. That is why I think they're allowing. But in future, if you are presenting a paper in one university, you can't be the author of other paper in the same conference. Okay,
I will keep that in mind.
that's a kind
I'll
of
keep that.
plagiarism. You'll understand it once you evolve and grow old. But yes, all right,
Okay.
please.
Thank you, ma'am.
Thank you, ma'am. I will keep that in mind from next time onwards. So,
Ma'am, can I ask Aman to
stop
stop sharing
sharing
so
your.
that I can share?
Aman Siddiqui, can you please stop here?
Yes, ma'am. Done.
All right, okay.
Thank you. Nishta, could you share the screen? We'll continue from the introduction. Um, uh, Thirdly, we have delved into cyber stalking, which is the persistent and intrusive online harassment which subjects women to constant fear and intimidation. And the fourth crime that we are dealing with is cyber hacking. That is the unauthorized access to digital devices or accounts that presents other significant threat to women's security and privacy online. This also includes identity theft, privacy loss, and also compromise of sensitive personal information. Now, based on all these four crimes, we have thrown light on the legal framework and also the judicial standpoints and also the incidents of these four crimes in our country. Now, while addressing these cyber crimes, it is also important to examine the existing legal framework and the judicial precedents, as I mentioned. And while these laws and regulations exist to combat cyber crimes, there are often gaps in enforcement and protection, particularly concerning women's rights and personal integrity in cyberspace. And therefore, its study on the same has also been made in our paper. Now, and also preserving the public's personal integrity and ensuring equal access to justice for all individuals, regardless of gender, is important. It is important to strengthen legal protections and also improve the law enforcement efforts to hold perpetrators accountable and provide adequate support and resources for these victims. This is an important facet of Article 21 of our Constitution, as I mentioned earlier. Not just that, it is also pertinent to note that several women do not come forward to file complaints, either due to lack of awareness of the laws prevailing or the fear of secondary victimization and victim blaming that exists in our country due to internalized misogyny and patriarchy. Now, through the recommendations that we have provided to improve the legal frameworks and identification of prevalent laws, we have also sought to raise awareness of the existing redressal mechanisms and also improve the existing legal landscape parallelly. Moving on to the research questions. So the first question that we dealt with is the impact of the cyber crimes on personal integrity and how they affect women's rights in the digital realm. Now, understanding the specific impacts of cyber crimes on personal integrity helps highlight the urgency of implementing these effective measures in order to protect the women's rights and well-being in digital environments. The second question is, what are the legal precedents related to cybercrimes against personal integrity, particularly those impacting women? By analyzing these legal precedents, we will gain an insight as to the efficiency of the current laws in our country and also guide efforts towards strengthening the legal protection and also thereby enhancing accountability for the cybercrimes against women. Some of the legal precedents that we have cited are Animesh Boxi versus State of West Bengal versus Animesh Boxi, and then Subranshu Raut versus State of Odisha, and Subhendu Nath versus State of West Bengal, among other precedents as well. The third question is, what are the implementable recommendations for fostering an environment where digital space is safe for women and their personal integrity to be protected? We have provided for actionable recommendations that will provide a roadmap for policymakers, law enforcement agencies, technology companies as well for that matter, and civil society organizations to collaborate effectively and also to create an inclusive digital environment that prioritizes the safety and the well-being of women. Next, Nishta will take over for the next topic.
Good evening, ma'am. With regard to the next topic, which is regarding methodology, we have dealt with a qualitative and a case study methodology for our paper. Qualitative in the sense of providing with supplementary sources, supplementary essence for the paper through secondary sources, where we have included the previously available measures that are provided in other papers. Moreover, with case study methodology, it includes we have included a lot of precedent cases and other case studies through which we have enhanced the subject knowledge of cybercrime and with regard to particular gender-based cybercrimes. And this method have we have provided various safeguard measures through through the other case studies from the other papers as a process of providing cyber crimes and what are the measures against these against women who have been a victim for these cyber crime. We have also concentrated on victim support methodology, where a method where cyber crimes are against victims who are not able to come forward and provide their own requirements. So, and furthermore, we have recommendations which will be explained through this paper now.
Moving on, we have the utility and contribution of the research. So, firstly is legal analysis. So, by analyzing these legal precedents and those provisions, our research paper has provided an insight to its effectiveness in addressing the cybercrimes against women's personal integrity, and this in turn has helped us identify areas for improvement and also strengthening legal protections for that matter. Secondly, policy recommendations. We have made several suggestions and implementable and practical recommendations that will be further elaborated by my co-author in the next upcoming slides. And thirdly, by using case study analysis, we have tried to understand how things have been dealt with by the judiciary in the past and how it can be dealt with using these recommendations. And a better understanding of cybercrimes against women based on personal integrity is important because by exploring these nuances of cybercrimes that targets personal integrity, the research deepens our understanding of the underlying factors, motivations, and also consequences of the crimes that and thereby contributing to our efforts to combating them effectively. And not to mention awareness and empowerment. So, our research also raises awareness about the prevalence and seriousness of cybercrimes as well as the legal landscape that exists right now, so as to ensure that women can come forward and file complaints and that there are redressals that are available in place through even though there are not specific laws per se for this. if we look into several legal precedents that we have cited, like for example, in the case of state of West Bengal versus Animesh Boxy, a student, an engineering student who was guilty for disseminating intimate videos and images of his ex-girlfriend on pornographic websites, was sentenced to 5 years of imprisonment and was charged under multiple sections under the IPC, that is section 340, 354 of A, 354 of C, 354 of D, and 509, along with 66E, 66C, 67, and 67A of IT Act of 2000. So all of these show evidence that there are redressals in place and that women can approach it. But at the same time, we have also we also aim to show to light the fact that there is incidents of victim blaming and secondary victimizations being the two reasons that, in our opinion, that women do not come forward with their grievances, along with the fact that they lack awareness and the general fear of being judged in the society. So now, through this analysis and insights, our research has sought to contribute to the gender-based violence in cyberspace, focusing on these four because of its surge in the recent times. Moving on to the next issue.
These are our major recommendations. With this, we would like to conclude our paper. So, the recommendations that we have provided here so far are with regard to enhancement and awareness programs, which basically helps in elevating women to come up and know what are the grievance mechanism, redressal mechanisms that they are provided with. Number two, these are the basic addressing the gender-based crimes through the legal framework, which provides a better understanding of proper protection through legal forms for any victim in that sense. For this, we have also focused on enforcement of such laws in digital forensics, which improves the legal mechanism and betterment of cybercrime redressals through such mechanism. For this, a specialized cell approach and a judicial support, whichever is provided, would be a useful recommendation, considering the fact that there are no specific a cyber cell where or a judiciary where such crimes are taken place and given a justice for. This paper has also focused on victim support mechanism, where victims are more supported to and are encouraged to bring out their problems to the light in the national stream. Moreover, collaborating with technological companies, which mainly includes the intermediaries such as the social media platforms, which are the companies which take up a mechanism to protect women or protect children against any of such cyber crimes against them. Through this, a collaboration of a government with technological companies would help in better redressals and better facilities for support and protection. Moreover, international cooperation, where cybercrime is not an individual person from an individual country, but rather an international question of necessity at this point for protection against cybercrime. International cooperation among different countries would help in protection of any victim who are framed through such cybercrimes.
Thank you, ma'am. Do you have any questions?
Thank you for the presentation, ma'am. For any questions? I'll just check upon her.
Can you just give me 2 minutes? I'll just get back.
Yes, ma'am.
Yes. So there is one question which I would want to ask you to, because if at all you people were present in this presentation, you would have seen that there were many presentations with respect to women, cybercrime, sexual harassment, whatnot. My question to you is that in India, if you focus on the laws, um, it's not like that we are living in ancient times and we do not have enough laws for such crimes, right? But then again, as you told, I think you only said that women, they don't go and file a case because they are afraid of um,
Victim blaming and secondary
yes,
victimization.
victimization. So my question to you is that what is that gap? There are laws, there are people, but there has to be something in between which is not connecting the two.
It's in our opinion, it's not just so, okay. In
You
our
are
opinion, sorry, ma'am.
Yes, continue. I'm listening.
Okay, okay. So, in our opinion, it's not just the awareness that plays a role in whether a woman is going to file a complaint or not. It's very deeply enrooted and institutionalized patriarchy and misogyny that our society has. There is a gap between someone going and filing a complaint and the laws that are prevalent because of several reasons. That is secondary victimization, victim blaming. There's a lot of not to mention there's a lot of honor killing that also happens in very grassroots levels and in rural areas where a woman's integrity is dependent upon whether
Yeah, but then
they're
these are the social causes. You have to understand that there is needs everywhere in every country.
yes,
These are
yes.
the social causes. There has to be some link between the social causes and the laws, which is missing. What do you think that is? Like, if I can give you an example, here in UAE, the laws, according to Indian laws, are very weak. It's like a tiny law. Constitution is very weak, but then still, the crime rates, cyberbullying, everything is very low compared to India. Why do you think that happens? Are we scaring the people? No. What happens?
Mom, personally, we think that it is not essentially the laws at hand, because we have a very good law that protect and safeguard women. But the gap that is missing here is proper more than awareness. It's about the um, it's about the societal the impact of society. And moreover, even with a lot of laws, the implementation of such a law is not at such a great rate, because
So you
the
think that the law
implementation,
enforcement agencies have needs to
there
fill
is a
the.
small gap.
All right. Okay. That's it. That's what I wanted to hear.
Yes.
All right.
Thank you,
So
mom.
we're done.
Thank you so much, ma'am.
We're done with the
Yes.
presentation. Thank you.
Thank you so much for the presentation. First of all, I would like to thank all the presenters who are over here, and I would like to thank Hasana ma'am for giving her valuable time. And I would also request her to please speak a few words about today's session and how she felt about the presenters and how the overall experience was.
Yeah. Am I audible? I think the presentation was really good because generally whenever we think about a conference, it's the same topic every time. And when we talk about AI, it's just AI. So here we have included gender, data, technology, AI. So it was a vast umbrella in which we could see different topics coming from different presenters. And I'm really amazed by a lot of topics presented by many candidates. Honestly, there were few topics which I never thought of, or maybe it was not my area of field. So it was a learning experience for me as well. And yes, thank you all. And yeah, it was a great experience on my behalf. Thank you.
Thank you, ma'am. Thank you, all the presenters. And I hope it was a very good experience for all of you to present and for ma'am to judge. We learned a lot from this session. It was very fruitful. As ma'am said, there were a lot of diverse topics. There were a lot of diverse topics from which we could take a lot of content from and new insights into it. We really look further to seeing all of them ahead. And yes, I would like to thank all of them for coming and giving your valuable time. We'll be ending this meeting with this. Thank you.
Thank you so much.
Thank you so much,
Thank you,
ma'am.
ma'am.
Thank you, mom.